Where it stops, no one knows. We're going head into the unknown. Na, 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 na.
Well, hello, everybody. Happy Tuesday. Welcome back to Criminality. Or if this is your first time here, welcome to Criminality. I am very excited about today's panel guests. And if you guys read the description, we are having a Q&A on all things Delphi. And I have the lovely Sleuthy Goosey. Hi, Sleuthy.
What up?
I have the beautiful All Eyes.
Hello.
Hello. And the uber intelligent Andrea Burkhart. Thank you guys for being here with us.
Yay! I would do a clapping if we had any sounds, Teresa.
I don't have sounds. I don't know what to tell you. So I'm very excited because this way people who have either, kind of gone, from following Delphi to stepping back and no longer kind of looking at it, people who are new to the case, people who followed the entire time but still have questions. This is an opportunity for you guys, the chat, to be able to ask all the questions that you guys have regarding the Delphi case. I want to be very clear. I'm trying to keep it as fact-oriented as possible, something that one of us on the panel can show you or tell you based on information that has either been presented by law enforcement, presented in court documents, or presented at trial. Instead of it being like, hey, what do you think about so-and-so as a suspect? Joe Blow over there, what do you think of him as a suspect? My theories on the case, or anybody on the panel's theories on the case, I don't necessarily want to dive too far into that. I want to try to stick to what we can show you as factual information regarding the state of Indiana versus Richard Allen, and where we are currently at on the case. If anybody doesn't know, he was convicted last year, November 11th of 2024. He's been sentenced to 130 years in prison for the murders of Abby and Libby. If your general question right off the bat is, where do I stand? I believe that Richard Allen is 100% an innocent man who has been locked up for a crime that he did not commit and had nothing at all to do with. So I'll let the panel guests speak for themselves if they want to add to that. But that's my standing. So that's where, if you go back in my old videos, you'll see how I got here. But so
Free
I'm trying
Rick Allen.
What?
I said free Rick Allen.
Free Rick Allen, yes. So it's really just kind of there's no fences anymore, Carrie Sherry. So it's really just, if you guys have questions, I want to be able to give you guys as much factual information as possible. If you want to do a theory live where we just sit here and discuss everybody's theories on the case, by all means we can do that, but that's just not this one. So because currently we are actually in the stage where Richard Allen's appellate attorneys have I think about 15 days left. Somebody on panel, correct me if I'm wrong.
I believe I want to say December 11th. I'll have to look. That
Yeah,
might
I
have
think
been.
you're right.
Okay. I think that was also November 11th that Jody had until, but it's also for the appeal too. They might do it a little sooner, but it's due no later than that day.
December 11th, you said?
Yes.
Okay, perfect. So I thought, we had so many questions on that, on where the appeal is at. What does that mean? What does it look like? And I thought, well, why not just have Andrea start off with that so we can kind of get where we're at live in the Richard Allen case, and then we can go backwards and kind of go through whatever questions you guys have from the past. So, Andrea, if you wouldn't mind, just kind of give us the overall of the appeal, what it looks like, why we're doing it, and how does it work?
Yeah. So the most important thing to understand about the appeal and what it is that it is reviewing everything that happened in the case so far. It's looking at the decisions that were made, the justifications for them, and whether any of those were legally incorrect. What it is very much not, and it's important to understand this distinction, it is not about whether Richard Allen was innocent or guilty. It's about whether there was an error that somehow undermined the confidence in his trial. And so, what it tends to focus on is legal rulings that were made by the judge and basically the impact that those rulings had. Some rulings over the course of a case they might be incorrect, but they won't have any real significant impact. They're minor in the grand scheme of things. And so appeals are really focused on errors that have the potential to contribute to an unjust outcome. So where we're at in the appeal process right now is still very early on, which is it's crazy because we are a year out from Richard Allen being convicted, and we've barely gotten underway with the appeal. But that is kind of par for the course. It's a very extended process. And this is also a lengthy case. It's quite complicated. There has been quite a bit of litigation. The trial was extended. So there's just a lot of material to go through and review and analyze. So the first step in the process is that Richard Allen is going to be filing his opening brief. And that's what's expected to be due in the next 2.5 weeks here or so. And that's where he will essentially formally tell us and tell the court what he is alleging the errors are that means he should have a new trial, or the convictions should be thrown out, whatever exactly his claim is, and the remedy that he's arguing is appropriate for that error. He'll be providing kind of his statement of the facts that are pertinent to those issues, like what happened as documented in the record of the proceedings in the court. He's going to be providing legal argument on the error itself. What does the case law say? What do the statutes say? What should the ruling have been? How do we know that? And then he'll be making arguments about how they affected the trial. In what way did it prejudice him that this particular decision was made? So once he files his brief, then the state has an opportunity to respond. I wouldn't be surprised. It's like I said, it's already been a year and we're still at the very beginning. So it wouldn't surprise me at all if the state ends up with a little bit of extra time to respond to theirs. But normally the deadline is 30 days after Richard Allen's brief is filed. Once the reply, or once the state has an opportunity to respond, then he has another 15 days to file a reply. And so that's the briefing stage. Once the case is briefed, it's typically submitted to the court. They review everything. They do their own research. The case, I'm not sure in Indiana if oral argument always happens. No, it says it's in the court's discretion. I've got the rules up here, so I'm just checking them. So you don't have oral argument in every case, but if there are significant legal issues, significant factual issues, or often just a case that's high profile, it's relatively common for oral argument to be granted. So it wouldn't surprise me at all to see that in this case. And then ultimately, when the court believes it has found enough, it will issue its opinion. It'll be in writing. We'll be able to get a copy of it, and then we evaluate where to go from there.
So a couple of clarifying questions that I know that have come up in chats. One, are the appellate attorneys the same attorneys as his defense attorneys?
They're not. So he's been appointed attorneys specifically for the purpose of appeal. There's a couple of reasons why they do that. One is that the appeal process is quite different from being in trial. It's a very different mindset. It's a different skill set and focus. And so you typically have specialists in those different areas. So he's got folks that are basically appellate specialists who are, know the ins and outs of this process and are well versed in it. But the other reason is because one of the potential issues that always has to be evaluated on appeal is whether the trial counsel provided ineffective assistance of counsel. And that's something that you typically want to have an outside lawyer reviewing it and exercising their independent judgment on it. Not that a trial lawyer would never, fall on their sword and admit that they've been ineffective. It happens all the time. But it's just you can get tunnel vision, or you see things from the perspective of having made that decision and maybe justifying it, whereas a second set of eyes will have a different view on it.
Good answer. So, okay. So then the next question is, you said the state has 15 days to respond once Richard Allen's appellate attorneys filed their brief.
They have 30. They have 30.
They have 30. He has 15 after that. Okay. So he has 30 days. The state has 30 days to respond. Who is the state? Is that still Nick McClelland and the Carroll County Prosecutor's Office, or is that a completely different set of attorneys as well?
That is a great question. And I don't actually know how they do that. I would defer to Kara or Michael Michael Osbrook on either of those questions. I really don't know. They do it different ways in different jurisdictions. So yeah, it really could be either.
Okay, I know Michael's in chat, so maybe he'll be able to answer. Not going to be raising just well.
I believe they were appointed from the Attorney General's office, I think.
That's what I was wondering. Two lawyers at the NC office.
Yes, there you go.
Yeah, that would make sense.
Okay.
Thank you, Michael.
So then
there's another question. How many attorneys can both sides have? I'm thinking of the amount of stuff in this case. Can they have more than two if they need it? If they think this is going to go on forever and ever?
I think they can. I mean, my understanding is that although the defense attorneys are appointed from the central kind of state agency, that the cost of the appeal is still borne, at least some part of it is borne by Carroll County. And so I'm not sure if they have the opportunity to kind of have a voice in what they think is appropriate resources or not. If Carroll County has a say, then, it wouldn't surprise me if they, think it would not be a good use of defense funds to do X, Y, and Z. Because, there's already a practice of that when it came to coming up with defense experts and investigation and things like that. But if it's independently funded by the state, I would expect there's maybe a better prospect that they'd be a little bit more generous with the public purse.
Can I ask another question?
Yeah, I know you're putting them. Sleuthie's grabbing the questions from chat and sticking them in our private chat so that we can see them too. So that's perfect.
So another one is, what are the top 2 or 3 issues that you think will be included in the appeal?
Well, I think the number one issue that looks to me to be the most obvious, it's the most glaring, is the denial of the right to present a third-party culprit defense. This was an issue that started getting litigated kind of early on with the Franks motion. There was immediate hostility, towards the mere idea that he might have a defense from the bench. And so that whole avenue kind of got squelched early on. But we never really got a great explanation for why that is. We just heard Judge Cannoni say over and over again, well, there's no nexus. There's no nexus.
Judge Cannoni.
Did I say Judge Cannoni? Go ahead. I keep
it's like they're interchangeable sometimes.
Yeah, it's easy.
It really is. Judge Gohl, who is oh God, a gazillion times worse than Judge Cannoni. Judge Gohl was very hostile to it from the outset, and she would just say there's no nexus, but she never explained what a nexus was, so that you might be able to argue how the evidence for some of these other culprits, these other potential culprits, quite a bit of which was,
In
I thought,
fairness, Andrea, she did make the
extremely compelling.
comment about
She
there's
did.
no DNA.
He did make a comment about no
nexus.
DNA. She said that in court while I was there, when they
Right.
were renewing that request at the end of the state's case, and she's throwing this out as an example of, like, there's no adequate nexus, there's no DNA. We're like, so where's Richard Allen's DNA? Because
Exactly.
there's none of that anywhere. There's apparently male DNA, all over the girls, and yet, not associated with any particular person, and not really the greatest explanation for, was it entirely unsuitable for comparison? Did you just not, identify other people? Like, not
So,
a whole lot of clarity about the status of that evidence.
so do you think that it'll be helpful to that, like when the appeal judges or whatever you call them, when they're reviewing that particular issue, if that is an issue, will they look at it and say, okay, she made this determination that there was no nexus based off of the fact that they didn't have DNA, and that's it, because that's the only explanation that she gave. Will they use that as the only explanation that she gave and say that's absolutely wrong?
No, I don't think that they will. She didn't say it as like, that's required. She was using it
Yeah.
as just an example of what's lacking, of kind of like one thing that maybe would be enough to
Yeah.
establish a nexus, but not the only thing that would be established. There's plenty of cases that have no DNA, and you're still able to go out and prosecute somebody for it. So it's clearly like not that standard. The way that the standard is articulated in Indiana, I don't remember the exact verbiage of it, but it's essentially along the lines of, you have to have a non-speculative connection between the person, the perpetrator, and the crime, and that can be a combination of motive and opportunity. It just needs to be more than some kind of shotgun. Well, hey, this person like existed in the vicinity, and so therefore maybe it was them. You have to have some direct evidence to show they were actually potential perpetrators of the crime, and not just not just kind of in the area. And so they abundantly had that in this case with a number of these different suspects that were put forward. They had blown alibis, they had contacts, connections with the victim, they had these backgrounds that provided some kind of explanatory context for the bizarre characteristics of the crime scene. They had strange admissions being made. They had third parties claiming that incriminating statements, people implicating themselves and others in this killing had taken place. So in many ways, when I looked at the third party case after, sitting through the entire trial and waiting to see what they had for Richard Allen, I'm like, I don't see how you don't have more against some of these third party culprits than you have to be suspicious of Richard Allen.
Especially when you have confessions from these folk that's literally considered direct evidence.
Yeah.
So how is that not enough of a nexus when it's direct evidence, that not even circumstantial? We're not even throwing out the circumstantial. We're throwing out what Indiana deems as direct evidence is somebody who confesses. We have multiple people confessing. There's no nexus.
Yeah.
Can I tell you one of my concerns with all of this is, my concern is that they're going to come back and just say, well, this may be true, and this may be true, and this may be true. But if our standard, which I don't know what standards for which issues they would raise, what they would be, but my concern has been that they're going to say, even if all of that is true, the jury still likely would have found him guilty because he made all of these confessions, quote confessions.
And I think that's legitimate. If the court, I'm gonna unfortunately give us a kind of hard reality about the appellate process and honestly just kind of legal practice in general, which is that we like to think this is objective ivory tower stuff, that people are the court is is just looking at the law, and the court is taking in the facts as they're presented, and they're looking at it holistically, and they're letting the principles of the law guide their decision. But the reality is judges are human. A lot of law is often outcome driven. And so what do they want to do? You can often find a justification for what you want to do, just depending on what part of the law you want to look at, which sentence you want to cite, and all of that. So if the court wants to take a very narrow view of the situation like that, say, well, he confessed and that's the end of the story, they have the power to do that. The problem with it, and the way I would be arguing it, from an appellate counsel standpoint, is that the confessions themselves are not overwhelming. You have to look at the confessions in the context in which they took place. That, of course, was a significant aspect of the defense case. There's quite a substantial record of that. The deterioration in his condition, the fact that he was recognized to be floridly psychotic at the time that he's saying these things, the actual content of the statements themselves being, not particularly incriminating, like 99%, like, I think maybe I did it. Did I do it? I could have done it. I think I
did it evidently. He said evidently. One of the first times he confessed to it, he's like, I think I did it. I think I did it evidently, as if he had just learned that he did it.
They're saying I did it, so I think I did it.
Well, it's like he's reading stuff, and expert, he remembers Holden saying, experts say. And so he's like, I guess I did. Like, I don't think he was very lucid, but evidently that one gets me every time.
So, I mean, I think if the court is looking at all this stuff fairly and in context, the ultimate question it has to ask is, look, if the jury had known all of this other additional evidence about these potential third-party culprits, is there a possibility? Not is it even probable? You don't typically have to show probability, because the right to present a defense is of constitutional magnitude. The Constitution says you get to do this. And so is there a reasonable probability that the jury might have said, this introduces some doubt for me about whether he really is the guy? They don't have any DNA. He doesn't look like any of the people that were described as being on the bridge. He denies that he was there. They tell us he said all these things in his interrogation that were incriminating, but we hear the interrogation itself, and he doesn't say those things. He described seeing different people on the bridge than the people the state is saying that he saw. His car wasn't there. Like, there's just all of these things that you could point at to say, so if the jury then knew that there were these other individuals who had these potential connections to the crime, is that enough that they might think, well, knowing that maybe Richard Allen isn't the guy that did it? That to me seems like much more of a no-brainer than if they just take the closed approach. Oh, well, he confessed, we want to affirm it anyway because that's the easy decision to make.
So that kind of leads into one of the questions from chat, was like, so can a new trial just be granted? Like, can we just grant it? Like, can the appellate court just grant a new trial just based on, without having to hear oral arguments or go through the rest of it? And they just say,
I mean, they have to go through the briefing. They have to go through the briefing stage. They have to have a reason for it. And they're not going to get that without, without the parties fleshing out why they should or should not have a new trial. But it's absolutely one of the remedies that's available for them. And even if they don't have oral argument in the case, I don't know what the culture is in Indiana. It's one of the downsides of, not being your home court in a different jurisdiction, because even though you have like the rules and everything that people can access, there's oftentimes just kind of cultures and norms and stuff like that you don't really get to know unless you practice in that court. Where I practice, generally speaking, I hate to see a notice of oral argument, because it means I'm probably going to lose. It means that they want to bolster up their argument against my position before they rule against me. I won far more cases that were not argued than I ever did that were. So I don't know if that's going to be maybe the same, but it's very much possible to win a case that doesn't go to oral argument.
I wonder if so we know that the third party culprit defense, not allowing that in, is likely one. What about What about her booting off the defense attorneys and them having to go higher up than her to get put back on, and did immediately?
Yeah, that one, I'm not sure that that is going to be a viable avenue on appeal, and the main reason why is because the argument would be that it's cured. It got cured by the fact that it went up on appeal and they sent it back down. They said no, he gets to keep his same attorneys, the ones that were qualified, the ones that he wanted,
Yeah.
and so it's kind of a no harm, no foul situation. Now, had there been, for example, like a motion to continue the trial, to extend it because, hey, we got kicked off the case, we lost all this time, we had to spend all this effort defending ourselves against this unwarranted contempt proceeding that distracted us at the critical time that we're trying to prepare for trial, and weren't granted that might have been a good issue. But that's just not the way that the case unfolded. They pressed for a quick trial. That was what Mr. Allen wanted. Seeing his condition, it was probably, what he needed, what was really in his best interest. And so that was really the most imminent harm that would result from that decision she made once they did in fact get reinstated, was just not having enough time. But they didn't make an issue of that, so it's really not something that's preserved for appeal.
I have a question about that.
Mhm.
Was the motion to stay all proceedings, was that only for the contempt? I know they filed because they were trying to
Yes.
say, can we just focus back on, because at that time they were still planning to go to trial in May.
Yes, it
And
was just
so
for the contempt.
okay, so
Yeah.
they filed a motion to stay all proceedings, but then not too long after that, when they were trying to decide how long they were going to need, she tried to give them the bookends. Does that not fall into any of that at all? Or is it just not strong enough?
Um, I mean, my understanding of the stay was, yeah, that it was they're only specifically asking to stop the contempt proceeding and basically saying, let us get through the trial and then come back and deal with this issue of whether the attorneys need some kind of sanction. And so the problem is anything that you raise on appeal, like with extremely limited exceptions, it has to be something that you asked for in the trial court. You have to have presented it and preserved it in that forum. And so if they didn't specifically ask, stay the trial, then the appellate court is not going to look at it as something that the trial court did wrong, because the trial court was never asked to do that.
Okay.
So are we thinking that that's the only thing to bring up on appeal, is the third party? Like, is there any other ones?
No, I don't think that that's probably the only thing. I mean, I know that there are significant concerns about the safekeeping hearing, and the initial, denial of counsel, kind of
Oh, yeah.
interference with his right to counsel when they knew he was represented, and yet they're having these hearings affecting his rights, his liberty, without affording him access to his attorney, without giving his attorney an opportunity to be heard at the safekeeping hearing.
Mhm.
That one, I think, there's obvious procedural, like major red flags with that whole process and how it unfolded. It doesn't appear to be consistent with the statute. It's got these, denial of a Sixth Amendment right kind of implications to it. The question, I think, around that one comes down to if they are required to show harm, show something that affected the outcome, is it too attenuated to point to, the intervening, year, many months that took place, over which, he was treated as he was treated while in custody. His condition deteriorated. The question that the court is potentially going to have is, well, is that necessarily the safekeeping's fault? Is that because of the order, or is that just is that intervening? Those are choices that other people made that weren't necessarily foreseeable. They weren't a necessary consequence of the fact. Sorry, my dog is going crazy. Of the fact that decision was made. So that can be a potential complication, I think, with the safekeeping issue. If they do have to still show, prejudice, how it affected the outcome, that could just be a little challenging because of the time frame and what actually happened.
So I wonder if they could go down the path of, starting with the safekeeping, and then where he got put, how long he remained, and the conditions he was in, then leading to these confessions that was really a main part of their
I mean, he was under
case against him.
24-hour surveillance for weeks before he ever had a truly private conversation with counsel ever. I feel
Well,
like that in itself is just a huge, I don't know if it's something for direct appeal, but that seems like a big problem.
yeah, and I mean, and the fact that then when his attorneys were, going through the dog and pony show that they apparently had to go through to be able to get into the prison, and then they're like being
They
recorded.
filmed him. Yes.
Filmed their conversation. Like it's just incomprehensible to me.
Well, they said they didn't. At the first safekeeping hearing, the warden testified 6 separate times in his, like during his testimony, 6 separate instances. I guess he gave sworn testimony. There was no audio. And then at trial, all of a sudden they were like, oh, we can't play these because they have audio. So they had to like go back. I think there was a delay one of the days they were supposed to play them, and they couldn't do it that day because they had to make sure that they were muted.
I mean, even if there were no sound, I don't see why that would still not be a problem
Oh, it is.
when you're facing the man to a window, facing the camera, in clear view of the camera.
Well, I mean, was it just like that picture we saw of him? That picture that was released where he's beaten to hell, that was from a camcorder video. And I mean, that's like, is that how it was during the meetings? Like, how close was it? Because that was pretty straight on from him. I know they were trying to get an image of him, but like, did they stand him against the wall? Like they kept talking about how they put a chair in the middle of the room so that they could face directly straight at him. I feel like you could read his lips pretty easily that way.
Well, that was what they implied.
Exactly. And I mean, that is an important consideration too with confidentiality. Like confidentiality means that like you're not supposed to be able to intrude into our thought process, our communications or anything like that. And if you can, I mean, just by being there, you can see what document are we talking about? What are we looking at? What is important to us? And that's going to be telling you stuff about the defense strategy that's supposed to be off limits to you.
Max
So
said
yeah,
that
it's
actively,
confidentiality is
cover his
supposed to be
notes.
also eyes free.
They could see like what he was writing even because they were over his shoulder at one point. In his affidavit, he described like having to actively or like proactively cover his notes because they were not trying to be careful at all. They were anything they could get, they were going to try to record it. That's crazy to me.
So another question, and I think I already know the answer to this. I should have brought it up when we were talking about the DNA, but another question from the post was, is there any time during the appeal process that the attorneys can compel the testing of the DNA?
So this is a sort of nuanced answer because yes, they can, but it doesn't have anything to do with the appeal. So when you think about what happens after somebody is convicted, the best way to think about it is really there's 2 paths that it goes along. One of them is this appeal process that I've been talking about, where all we're doing is going back and looking at the process of what already happened in the trial court and whether there was a mistake made in any of that process. But there's a whole separate post-conviction process that can happen that is far more focused on the question of, is this guy innocent? Is there something that maybe happened that didn't make it into the record of the trial process below that should have for one reason or another? And so post-conviction relief can often be, it usually is significantly broader than the avenues that you have available to you on appeal. A post-conviction relief is most often going to be where you raise issues about ineffective assistance of counsel. It's where you're most often going to raise issues about prosecutorial misconduct, if there's been evidence that's withheld or things like that that are subsequently discovered, if there is new evidence that's developed. Those types of things are relevant in that process. So Indiana does have a post-conviction process to be able to request the testing of DNA. And according to the Indiana statute, that can be done at any time. It's completely independent of the appeal. They don't have to wait for the appeal to be done. It just requires, whoever is going to be counsel to initiate that process, basically to go through and initiate it.
So do you think that it would have been beneficial to begin, now that we're a year out from sentencing almost? We're past a year, aren't we?
We're past a year now.
Yeah.
Sentencing
So
was December, but it's the trial, the verdict was over a year.
So at this point, this whole year, I feel
Mhm.
like nothing has been done at all. Do you think that it would have been beneficial to have been working on post-conviction stuff, especially considering by the time that a conviction happened, it was already 8 years past the time that the crime happened?
Sure. Oh, 1,000,000%. Like the whole thing about post conviction relief is like you're saying, time is your enemy when it comes to a criminal case. And if you're wrongfully convicted, the longer that goes by, the less likely it's going to be that you're going to be able to uncover evidence that will exonerate you. Things get lost, people die, people forget, people move away, and you can no longer find them. All kinds of just not good things can take place the longer you delay. But there's another piece of it too, which is that you have some real strict guidelines to be able to get into federal court on habeas corpus relief, and those particular deadlines typically track the timeline of your appeal. It runs from the time that your appeal is concluded. Depending on if you have some kind of post conviction process, a petition process, or something like that in your state, you might be able to toll, meaning like put a hold on the federal deadline running while you go through the state process for post conviction relief. But if you don't do that, then your deadline for federal relief can run very, very quickly. And so that can be a huge disadvantage in a situation where maybe your state court is just not a particularly friendly environment for criminal defendants. And you need to have that opportunity to get into a different arena, get a different set of eyes, a different set of personalities, people who aren't necessarily going to all the same cocktail parties as the as the judges in the state court system, so that you can have a more fair shake at it. So because of that deadline, it's like all the more reason why, really, if you can, I would never advise anybody to delay like a second in pursuing post conviction investigation. Other avenues, things that can come up, things like jury misconduct. You want to, if you can, you want to be able to talk to the jurors. Depends on if it's allowed in your jurisdiction or not, but that kind of investigation, because that's stuff that doesn't necessarily end up in the record. You often have to pursue that outside. You need to follow up on maybe leads that weren't followed up on. You need to be reviewing the whole defense attorney's file so that you can see, here's what they had. What did they do with it? Is there something that they overlooked? If I go and follow up on that, what do I find? Post-conviction investigation can just be a really massive undertaking with a very tight time frame to be able to get it done.
Yeah, and don't forget, the defense requested an order to preserve all the evidence that was denied.
Because it wasn't specific enough, even though they were specific. They said preserve all of it. Like did she want an itemized list of an almost decades-long investigation? Or I feel like all evidence was clear enough, but her reasoning didn't really address what they were requesting. I still don't understand that one.
Oh,
to a sane and reasonable court, all evidence is absolutely specific. No, there's no confusion about the scope of what that means. It means all of it.
That's actually a really good point to bring up.
It's warranted too, because they've already deleted some. Like that is, they should be requesting that, because these people cannot be trusted to do it on their own anyway.
I'm glad you brought that up about her reasoning and actually lack of reason, lack of an explanation ever with every single order as to why she was ruling a particular way. Do you think that that's going to be an issue for the appellate judges, I guess? Because are they just going to assume all the reasons why she could have denied things and oh yeah, that's great. So she knows what she's doing.
Yeah. Yep. That's exactly what it is. And so, because if she goes on the record with the basis for her decision, then they get to go in and review that. And if there's any mistake in it, then that's potentially gonna get her reversed. But if she doesn't say anything at all, then they're assuming it could be anything. It could be any of the possible reasons why this ruling might be upheld. And so she gets the benefit of the doubt by being more ambiguous. It's one of these kind of just maybe unintended consequence of the appeal process and in the way that it works, and kind of some of the presumptions that are at play, the deference that is given to the trial court and the trial court's rulings. That the less specific you are, the more likely potentially it is that they're going to say no problem.
I'm
What about her
sorry. I'm
clearing one of the-
disgusted.
Oh, sorry. Go ahead.
No, I'm disgusted by that. Truly, I think that it should be absolutely a requirement that they give a reason for their rulings.
Yeah.
Mm-hmm. I agree.
That's vile to me.
I agree.
We
We have in Washington, we have very specific types of rulings where they have to be very specific with their findings. And so it's set out by rule, like exactly what you have to consider, for this and for that. And you have to make findings on it. And, like the format is laid out more or less. But it's pretty limited. It's just dealing with if your confession is going to be suppressed, or if there's, a motion to suppress evidence based on a constitutional violation. You have to go on record to state your basis so that they can adequately review it. Because the reality is, courts of appeal should not like this at all. It makes them have to work so much harder to do the job of the trial court that the trial court isn't doing. But if they're not going to, drop the hammer and kind of enforce that and make that be required, then there's no incentive independently for the trial court to do that, because all it has the potential to do is just get them reversed.
Okay, I have a question on that note about ruling. I guess when it comes to evidence, like with the motion in limine, when it came to the geofence data, her ruling on it was not specific, but the prosecutor requested it to be liminated out, and he conflated all of the data from, like, the tower data from AT&T with the geolocation data from Google. Those are two entirely separate data sets from two entirely separate things, but he presented them as one and gave them all the same level of accuracy and how reliable they are. And she excluded it based on the way the prosecutor requested it and framed it. Is that just one of those things that's going to drive me crazy, or is that an actual issue? Because I feel like it's an issue to exclude it when you're excluding it based on a false presentation.
Yeah, no, I agree completely. This is one of the issues I would be looking at very closely if I'm appellate counsel, because the geofence data is extremely important to establishing, was Richard Allen even there when they say he was there? Who else was there that is potentially a third party culprit? All of that type of thing. And so typically when the Court of Appeals is reviewing a trial court's decision to admit or deny, exclude evidence, they're going to be doing that under what's called an abuse of discretion standard. The idea is that the trial court generally has, discretion, because a lot of the evidentiary decisions are based on, we're weighing different things. We're weighing, like, how valuable is it versus how potentially prejudicial is it? And so those are the types of things that the trial court or the Court of Appeals doesn't want to get in the habit of second guessing that. So they just defer to how the trial court kind of makes these weighing types of decisions. But the problem is that the decision still has to be grounded in correct law and in a sufficient factual basis. And one of the important things about a sufficient factual basis is that what prosecutors say in court is not evidence. It is argument. It is not evidence. It is mere assertion. And so nothing that the prosecutor says should be given or taken as having the weight of testimony. If your argument is that this is unreliable, you need to be presenting expert testimony, somebody who is qualified in this field, who is saying that and who is explaining why it is unreliable. So just having a prosecutor say this is unreliable doesn't establish a factual basis whatsoever. So yeah, I'm definitely looking at the exclusion of the geofence data if I'm the appellate lawyer.
So
go ahead.
The judge is the one who's literally saying to Nick, like, okay, you think it's unreliable, we just won't have it in here. And then you have the appellate court who's just trusting the judge's decisions.
Well, they're giving deference to the judge's decisions. They aren't. It's not like a free pass to just do whatever she wants. She still has to follow rules of evidence, and she has to start from the presumption that, number one, the defense has a constitutional right to present an appeal, to present a defense, and number two, that relevant evidence is presumed to be admissible if it's not unduly prejudicial. So if it meets the standards, for admission, and you don't have a factual basis to say here's why it doesn't meet the standard for admission, then you generally should be allowed to present it. So yeah, without any kind of significant record for what exactly is it that makes this particular data a problem, and like All Eyes is pointing out, this is so frustrating from an outsider's kind of standpoint, because yeah, these are very different types of data. They have very different sources, different precisions, and so forth. That to just kind of lump this all in and throw it out, particularly when I, as a defense attorney, I'm so used to just seeing the state, throw this stuff in front of a jury in case after case after case. It's not a good foundation for that decision. It's not well grounded in anything that she is supposed to be relying on as a judge.
So then I have a question about your thoughts with the bullet, since we're kind of here. Is they originally filed a motion to suppress the ballistic stuff, and with no hearing from no experts, she said no. And that was the end of that. Then they went to suppress the results of the search warrant at his house. She said no, file a Frank's motion.
File a Frank's motion, get in trouble for filing a Frank's motion.
Correct. Yeah. And so I find it interesting that, and then carrying that on into the trial where they had that metal allergist or whatever, and they wanted him, and she said, no, you already have a ballistics person. Well, then the jury literally asked a question that a metal allergist would have been able to answer.
Well, she excluded him because he has never done one of the magic microscope tests that are, it's like her report was like, that was not an examination. What she did was not anything. It was not science. And Goal excluded him because he doesn't have any experience doing non-scientific stuff. I can't get over that one either. I think her reasoning behind it I don't understand it. Even from her perspective, trying to, I don't get it, because he's never done an unreliable thing. How does that exclude him from testifying to what she should have been doing?
I mean, it was like this unfair kind of expansion of the scope of what he was being offered for. Nobody was offering him as that kind of expert, and so then she was taking that and kind of turning that into a test for relevance. Like somehow it's not relevant if that's not what he's there to talk about.
There's no nexus to need a metallurgist.
Well, it's a metal bullet, and we're talking about forces on a metal cartridge, and so right. It seems obvious, how this is potentially relevant. But that was just kind of par for the course for Goal. If she didn't want to see it, she would simply refuse to see it, and she would insist that it's not there and that nobody else could see it either.
Okay, I have one question sort of along the last two lines before we get too far away from it. When she ruled on, I think it was the May 31st order, after all of the back and forth between people, Nick was in contempt of her 2022 order of like the ex parte filings where he accessed filings he wasn't supposed to, and then he put it in a new filing and made it public so everybody found out who the psychiatrist or the psychologist was. But in that same order, she went through a whole litany of things that had been happening, and randomly in the middle of this order, she clears the third party suspects in an order denying another Frank's hearing or another Frank's motion without a hearing. How I can't even hardly say it, because how do you clear someone if you're denying a motion without even hearing the evidence on it?
Yeah, I mean, you're not clearing anybody. I mean, that's a decision that it doesn't really have legal significance because she's not in the position to clear anybody or not clear anybody. She's just there to say if evidence is admissible or if it's not admissible. They weren't charged with anything. They weren't, adjudicated in any kind of way. So it's sort of just like her, thinking out loud, injecting her own opinion might speak a little to the bias that was abundantly evident throughout the course of the case. But for practical purposes, that was for the papers, for somebody who was like so accusatory towards the defense in particular, how dare you, respond to these accusations in public to the media, issue this press release to respond to the claims that the state has made and so forth. That type of thing, it's legally superfluous. There is no reason to do that except so that it might get picked up on and become part of the public conversation. Oh, these third-party culprits, they've been cleared.
So do you think bias is something that will come up on appeal?
Bias, I doubt it will come up on appeal. And
Yeah.
the main reason why is just because the standard to get a reversal for bias is extremely high. You have to show actual bias, not just she maybe didn't like us, and it's a very difficult standard to meet. Typically, just the fact that she ruled against you is not going to be enough. They want to see something more. They want to see like, oh, she's got a financial interest in the case. Oh, she's got a personal relationship with somebody who's involved in it. Something like that's pretty cut and dry and easy to establish. But just she ruled against us repeatedly and treated us unfairly, like it should. But the reality is that courts don't like to call each other out. There's
Right.
all this kind of bending over backwards. Like I said, this is a political position. There's a lot of the cocktail party set going on with it. And so they don't want to be in that position of, looking like they're calling out or second guessing somebody who, is just doing their best, doing their duty or whatever.
Well, what about the contempt stuff though? Because she had a whole hearing to see if defense was in contempt of the gag order, and she eventually found that it was merely potentially violative of the rules of professional conduct, even though it wasn't. The fact, like, they should have issued something, because there had been almost a decade of press conferences by the state, and they had a whole thing on Halloween after his arrest to announce his name and basically put his name to it and then seal the PCA. So everybody had almost a month before there was even his first hearing and before he even had counsel. They're like framing the whole thing. So defense should have put something out, and it was like a textbook example of how to follow those rules on publicity. But then when the prosecutor straight up violates one of her orders and is in actual contempt, she didn't even reprimand him. She just asked him to take the filing down. Even stuff like that, even though that is clearly unfair, it's clearly biased, you're saying that just it's not, even if it's true, it's just not a strong thing to go for, I guess.
The way that I would handle this if I were working on this case, as a standalone appeal issue, it's not helpful. But
Yeah.
you better believe I am going to tell the story of what happened in this case in a way that makes it clear how biased it was. It's not a strong standalone legal basis for reversal, but it's such an important part of the context that I'm not going to leave it out of the story. Like, you're gonna read my brief and the way I present the facts, and you're gonna understand loud and clear that I never was going to get a fair shake in this courtroom.
Right. Okay, I guess that does answer my question, because I thought maybe it was you just don't even bring it up because it just automatically, they don't like it, so you just don't even go there at all. But you can, I guess, kind of sprinkle it throughout the briefing to give it the proper context.
What you do is you just show what happened, and you let them reach their own conclusion. You don't call out bias. You don't raise it like that. You don't make it explicit. You don't tell them that it happened. You show them. You just show them.
Yeah.
And let them figure it out for themselves, because they'll read through the record. I'm not going to tell them anything that isn't actually citable, to the record. But it's going to paint a picture of how this whole process from the very beginning, it built and it built and it built in a way that just hemmed me in and made it more and more and more impossible that I was ever going to get a fair shake in front of a jury in that courtroom.
Okay, so if we, Sleuthia, all the ones in the back chat, have we asked those questions? I just want to make sure that we've got all those people's questions.
Yeah, I think so.
Okay, so then there's a couple more that have kind of to do with the appeal, so I want to ask those before we veer on to a different topic. One being, if the appeal is granted, what is the process for Rick's counsel and the timeline of deadlines? Like, I'm assuming that question really is, if the appeal is granted, when do we see something happening here?
Yeah, so typically when the appeal is granted, now again, the way it works in my state, and I'm not like a gazillion% sure about Indiana, but typically in my state, there's a time period between when the appeal is decided and your deadline to ask for the Indiana Supreme Court to take a look at it. And so both parties typically have, from the appeal, they have the right to go up to the Indiana Supreme Court and ask for review. So that timeline, whatever it is, it's usually about 30 days, is normally built into the appeal process. As far as like, you get the decision, this 30 days has to go by so that everybody has an opportunity to seek their further relief. If they don't do that, now the appeal is final and it gets sent back down to the trial court to follow out whatever it is that the appeals court says that they have to do. So in the case of a new trial, it means you got to get counsel, back on board, reappointed, figure out if it's going to be the same attorneys, if it's going to be new attorneys. You're going to just basically have to reset the trial date within the limits of whatever speedy trial obligations the particular rule puts you under. Sometimes there are different speedy trial limits for post appeal than there are just, starting it out the first time around.
Does it automatically drop back to Goals Court?
Yes. Yeah, typically they can, if there's some reason why they reassign it. It's not unheard of, but it's very rare. And part of the reason why is because they don't want a new judge to have to get up to speed on it. They were going to consider it more efficient to send it back to the court where it came from.
Even though she was a special judge and she was not up to speed on anything.
She thinks she's very up to speed on all the things.
Well, she probably does now, but if she's a special judge, can't they just appoint another one? I kind of thought you should be able to like plug and play them, like, because they are just there to call balls and strikes. Is that once you're at an appeal, is that different?
It's just that once the judge is assigned, they like to have continuity throughout the process. And it's the same with counsel too. Continuity of counsel is preferred. It's not always required because things happen. People might retire. People may not want to take up, the reappointment after what happened the first time around. And so same thing can happen with the judge. So it's not like you're guaranteed continuity, but they prefer it for efficiency's sake.
So for example, with a doctor, let's say you have a doctor and you have some type of acute condition that you need some help with, can any doctor treat you? Yeah, but is it more efficient if somebody who knows you and knows all of your past issues and has a lot of records on you?
Okay, but what if that doctor gave you an infection? If they, like this, I just feel it seems.
Doctor did give me an infection.
Yeah, I guess it's just hard for me to understand that in this case because it was like a tragedy of errors on her part, I feel like. And I feel like they've had so many chances to remove her and a lot of this could have been corrected and maybe even avoided a lot of stuff. At this point, it would just seem beyond parody for her to just give it back to her. We thought we were like, oh good, Diener's gone. A new judge, great. Yeah. Like it turned, like she was somehow, I think, worse than Diener, which is not an easy feat for anybody, I don't think. But maybe a third one would be even worse. Maybe it is better to just stick with the devil we know.
The devil you know.
Yeah.
I was gonna say at least it wasn't Shane Evans, my God. But could you imagine? So then my other question along that line is, because you were talking about all the things that would need to happen before a new trial. Obviously, another one would be to get Rick Allen in that state again, because he's not even in the state of Indiana anymore. What would happen if he were granted a new trial, and considering we don't know what his mental status is right now, what if he were determined to be incompetent? Or what if he's continued to suffer, let's say, head injuries and is no longer capable of assisting his own defense? Then what would happen?
So typically, if there's a competency issue, then you go through this kind of diversion process where there has to be the case is basically put on pause, and there has to be an evaluation of his condition. And what happens after that really just depends on what it is. If it's something like a brain injury where you may not have a prospect of being able to overcome that, then you might be in a situation where he's never going to be competent to be retried. And if that's the case, typically you got to dismiss the charges. You can't maintain that prosecution against somebody who isn't fit to be prosecuted. But what they will typically do is try to find you restorable, meaning they can pump you full of drugs and get you into a condition where you can parrot some information about who the participants to the case are and what their role is. And then by being able to do that, you're demonstrating your understanding of the process. So then they can say you're competent and you can be retried. The competency bar, very low.
That is scary as hell.
That's kind of what they're attempting to do with Meehan, I think.
Yep, I agree. Okay, so there's one more question.
They did try that.
Not that one. Wrong one. Sorry. Let me get to the right one. There was one more about the appeal. Did I lose it? I hope not. Okay. Could a Richard Allen appeal claim that the defense investigators were ineffective? Like, why was the more exculpatory phone data not explored more? I think we kind of touched on both of those, Hammy. Is there anything you want to elaborate on for those?
The issue with ineffective assistance is usually two things. One is it something that was actually raised at the trial, and kind of related? Do we have a good record of what the alternative would have been? So this is kind of the issue that you run into with ineffective assistance, where you end up kind of having to do it in the post-conviction process because you're talking about something the defense attorney didn't do. And if the defense attorney didn't do it, then necessarily it doesn't get presented in court. And so we don't necessarily know what it is. And if we don't know what it is, we can't say what possible outcome it had on the trial. So I don't anticipate seeing things like that in the appeal process. It's much more likely to see that come up if the case gets to post-conviction.
And then could they depose the defense attorneys and stuff like that in post-conviction?
That would be a Michael Osbrook question, because I'm not super familiar with what the process is available in Indiana. In my state, you're very limited with the kinds of tools you have available in post-conviction, unless you have to file your petition and kind of overcome an initial hurdle of, does this have any merit at all? And then if it does, you can get access to some limited discovery tools, like with some oversight from the court. But in order to actually file your petition in the first instance, you don't have any tools like that in Washington. Indiana might provide some expanded ability to do that, but typically once the trial is over, you've lost your power to subpoena witnesses, you've lost your power to depose people, you've lost your power to compel production of things. So it can be quite challenging if the state doesn't provide you with an avenue to be able to do that.
So then let me ask you one more thing about the appeal and a possible thing that get brought up. Now that we've seen, me and Teresa are like experts with these deposition readings. And now we know that in the beginning of 2024, so before the confessions, these alleged confessions, after he was appointed attorneys, Holman, Liggett, and Steve Mullen took it upon themselves to go up to Westville and put him in a interview room alone and try to talk to him. Could that be a problem?
And
It's a
during
major
this time, somebody put a mail stop on his letter from White County Jail requesting counsel, and it was
Yeah.
it was not mailed until after that was their unsuccessful attempt at visiting him.
Yeah.
So, and
Um,
Nick would know that he had counsel at that point. So what
yeah,
happens?
they did. This is major vibes of a Sixth Amendment violation. Again, it comes down to a question of, is this something that they have to show prejudiced him? Because if it did, what's the consequence? What happened as a result of that? He didn't talk to him, so they didn't get anything out of it that they were able to use. So it didn't necessarily affect the outcome. If it's the kind of violation that they consider this like structural, then you don't have to show prejudice. Like just the fact that they did it is bad enough to undermine the confidence in the process. Then it's a much stronger argument. But that's a very, very bad record for the state, because that's serious no stuff.
I feel like there's something to be said for the fact that that fat dummy said out of his own mouth
Which one?
that
Which one?
there are a lot of fat dummies. I meant Holman.
I knew you meant Holman.
Yeah, the worst one.
Biff.
Biff. The fat dummies.
The fact that he literally said that basically they put him somewhere bad so he'd have time to think about it. And then they went to
leverage him.
Yeah, and then they went to go see him without his attorneys knowing or being present. So he didn't talk to them, but they also had him in solitary confinement. They also did not let him see his wife, and he wasn't allowed to do anything like that until literally after he started making these statements. So I feel like I'm not a lawyer, so I don't know the most eloquent way to say it to a panel of judges, but I feel like there should be something to be said for the fact that there were A, B, C, D, and E things going on that led to F, which is these alleged confessions.
Yeah. Well, I think the artful legal language that you're going for is, does this shock the conscience? Because
it does mine.
Yeah, it really does mine too. I mean, it's absolutely horrifying. And that's kind of one of the difficulty looking at this from the appellate lawyer standpoint, is that this is so bad that it's largely unprecedented. Like, this is so far beyond the limits of even playing unfair, even like reasonably acceptable bad behavior. So you don't have a lot of case law out there dealing with situations like this, because these situations do not happen, because this is banana republic kind of stuff. So it's hard to be in a kind of novel environment like this, and sort out a way to present it that will convince the court to take it as seriously as you take it, because you can't point to some prior precedent that's binding that says, here's what the standard is, and here's the facts that you look at, and here's how it applies. Like, you have to convince them to make this a problem. And so the shocking the conscience is that's fundamental due process. That's a substantive due process issue, where this process has been so fundamentally, it's so unfair. Like, it's just so obviously shocking the conscience that it should not be tolerated in a free society. It's such a high bar to meet. And yet, I gotta say, if there's like any case that has the potential to be it's really got to be this one.
Well, can you clarify real quick, Sleuthy? Did you say, you said before the confessions, but after he had attorneys? I thought they went to go visit him before the new attorneys were appointed.
So he had attorneys in November. They went in the beginning of the year in 2024.
No, that's what they initially said during the hearings, but Holman clarified that it was like a week or so after they shipped him off.
Right. And then Liggett in his depots tries to say that he thinks it was actually in December.
Right, but it
even if it was in December,
so the whole issue is there's no log of them showing up at Westville.
Okay, so we didn't get
that we know of.
A very clear date, like, hey, let's just contact.
I thought it was a week or so, because remember those I have it on, I think on the prison timeline document, but there's those recordings that someone who was talking to I don't know if it was their husband, their son, their brother. They recorded their phone call with one of the inmates that were at Westville when they were clearing out the cell, getting ready for him. And he's telling her all about it. Like, yeah, the guards are the only ones allowed to bring him his food. We've been told. He even said there's the sheriff and state police were there to bring him there. And that was about a week or so after he was put there. And that was one of the things that Walla was talking about, how when they gave him his discovery, they took the inmate snitches off and replaced them with guards because they didn't want a repeat of what happened when he first got there. I know what Liggett said, but I actually think Holman's closer time-wise to when they actually did go there, because if not, who was that inmate talking about everybody showing up to like talk to him? And even the sergeant told one of the other inmates, "Oh, I'll fill you in later."
Well, you're also
wild to
going
me,
off
but
of what, inmate so-and-so is telling their girlfriend from prison or their cousin's mother's aunt from prison, and what all is hearsay that they heard from other
well,
inmates
true, but I mean
versus.
the
Is
timeline
there
of
any
it. Like,
time?
even
Is
if you
there any
find about what they
time?
said, that's the time he was there. Do you know what I
But
mean?
what I'm
Like,
saying is, there any time on this recorded call that was given, that was recorded by so and so's dog? Was there any time recorded on that? You know what I'm saying? Like, do we even know when that was actually taken?
yes, because it was right around the time of the November 22nd hearing, because the PCA still hadn't been unsealed yet, so it would have had to have been at least earlier than November, because this person was filling in the guy in prison about all the stuff people were saying on social media. She's like, "This is what I think." She told him this is all speculation, but they're thinking this, and they went and they one of the neighbors saw him. So like, even the timeline of the stuff that she was saying, it would have had to
But
have
earlier
been.
than November. What do you mean earlier than
Because
is November?
in the phone call, they're trying to talk about the PCA, and they're even talking about how weird it is that
But
it's
that's all in November. So that's what I'm trying to figure out. You said before November.
before the end of November, not
Oh,
before
end of
November.
November.
Yeah, sorry, before the end
Oh,
of
okay. That's
November.
what I wanted to
And
clarify.
so, and that does, I feel like that at least puts it before December. And so it could have still been after his attorneys were appointed, but I've been trying to zero in on that because I can't tell if this mail stop thing bothers me or not. Because
I agree with you.
like,
I
if
think
they
that
stopped
Holman's
his
probably
mail
more
requesting
accurate.
attorneys and then went to visit him, and then mail, because it got mailed, what was it? It was re-stamped, and then it was filed by November 7th. So in my mind, I'm like, did they stop it to go visit him? And then after it didn't go well, they're like, okay, fine, he can have attorneys now. So we'll remail it for him. Do you know what I mean? Like, that is,
I don't put anything past them. So, I mean, I
I
can
don't
see
either.
exactly why you feel that way. I do think it was probably closer to November. For me, and you guys can disagree, for me, it's more about the fact that they go up there. He already had an attorney. He had an attorney of record that Kathy had got him. Nick knew about this attorney.
Yep.
And then when if that attorney says, okay, they can't afford me, he knows he's going to be indigent and knows that he's going to have attorneys.
Well,
No matter
he's explicitly indicated he wants an attorney one way or another. He either
Right.
is going to hire somebody or wants somebody appointed. He does
Right.
not want to do this pro se by himself.
Right.
So I still think either way he's represented, and it is covered by it's covered. No matter whether you think it's the beginning of November, end of November, December, regardless, to me he's covered from the attorney point of view the entire time.
Gotcha. Okay.
But
I thought he was saying they
I'm
wanted
not-
to go because he didn't have any representation. Like, and that is just such a short window, because I also am having a hard time understanding how there's no record. Like, what prison can you go to without being checked in and checked out? Like, how
I
does
mean,
that
but
even
you're not a
happen?
police officer. Like, you're not the sheriff. You're not a police officer. You're not the state. You're not.
True, but if
So,
you want
like,
to interview someone, you have to go through some sort of process. Like, you would think they could figure out what day that happened. How
Not
has
if they don't
nobody
want
done that?
to.
exactly. Like, they brought him in there without asking questions. No one batted an eyelash. They let him be
Crazy.
treated the way he was, and no one batted an eyelash. Nobody seemed to care. So I don't think that anybody would have second guessed, like, a state trooper walking in saying, I need to talk to so and so. And I don't think they stood over his shoulder while he signed a visitor log, you know?
No, but you have the warden who's he's involved in this whole thing with the Holmans and the Liggetts and the Nick McClellan. Like this is all he's allowing them to just come in, come talk to him whenever you want to.
I'll give you a good example here. I'll give you a good example here. Okay. Rick is meeting with his attorney, or not his attorney, his that crackhead Walla, the therapist or whatever, the pseudo therapist, the Clarice,
The
okay?
predator. She
The
preys on
Clarice.
people.
And
Irene.
you know, nobody's supposed to know anything that's being said, okay? And one day out of the clear blue sky, right after, I think it was, I actually have the timeline, I can look it up. It was like 2 weeks after he makes this initial admission, I guess, that I did it. And all of a sudden, Nick McClellan is requesting his mental health and medical records from the prison.
Hmm.
And there are no reasons. He doesn't say we heard that he might be saying A, B, and C, just requests them and is denied them. Then a little while later, requests them again, denies them again. Third time, requests them again, denies them again. And he never, prior to the very first I did it, did he ask for any of those medical records. How did he know that there was anything to be seen in those medical records? And he tried repeatedly to the point where the judge was like, you know, and this is saying a lot from someone who doesn't really give a damn, but she's like, you know that you can't have those,
Yeah.
but if the defense keeps on bringing this up, then I'm going to let you have them. And it was eventually like stipulated to. The defense was like, we got all the records. We'll give them to him.
I think that's
He's been
why he
asking
wanted
for
them. I think he wanted to put defense in a position to say we're challenging his competency so that Nick could, like I think he was, because they had the recordings. The way they found out initially was because he was talking on the phone, and Harshman got all those recordings. And so when Nick started requesting them, then it could bring in all the other stuff. But he also got the letter, or not the letter, the order, the supplemental safekeeping order on the 14th when they had the TRC hearing about whether or not to give him involuntary medication. So that could have also played into it, but I do think he wanted defense to undermine his own competency. Think, like it was because he's a very good defense attorney, and he's doing it for the state. He's doing things that would normally be something you do for a defendant, except he's doing it for these just shameful officers and judge. I think that's what started it, though, because the first time he requested it was April 14th, and then again on the April 20th, and that was not long after the so-called confession started. That I did it. I think I did it.
Okay, the first one was like April 3rd or April 4th. So within 10 days,
Yeah.
10, 11 days of that very first one. My thing is, and this, I am firmly of this opinion, and I'll tell you why. In Wallace, no, well, technically Wallace, in Wallace slash, who was, now it's
Martin.
escape. No. Who was the lady for the defense that reviewed all the medical records?
Westcott.
Holly Westcott.
Yep, Westcott. Okay. In everybody's notes, there is a entry in March of
Mhm.
2024, pre-confessions, that Walla makes, where she says that she tells Rick that she has been in contact with the lead investigator.
Mhm.
I truly believe, because I see zero reason why his prison psychologist would need to be in contact with the lead investigator of the case. Zero. I see no reason why it was necessary. I'm firmly of the opinion that she was sharing information with said lead investigator, and I would bet I would bet Brad Weber's remaining thumb toe that she was fed information by the lead investigator to feed to Rick. Period. So I really have a lot of issues with all of this. Like I would be bringing up Walla too. I would be bringing up the fact that Walla went to visit him after he was moved. Why
I'm
are
at
you
the
going
point
to
where,
see
like,
him?
if it's the appeal that gets Walla brought up, or if it's the post-conviction relief that gets Walla brought up,
Someone's coming for you, Walla.
somebody needs to come for Walla, without a doubt. Okay, so there's two questions left that I have about the appeal. So one is perjury something that can be attacked in an appeal?
Not really. Not really. I mean, perjury kind of just goes to credibility, and the problem with anything on appeal is that they are never going to second guess credibility determinations. That is solely the purview of the jury. The jury gets to decide who they believe and who they don't believe. And so even if people testify in ways that are contradictory to the evidence, if the jury believes the people, it's untouchable. There's nothing that you can do about that from an appeal standpoint. So for perjury, what you would really need to do is you would need to like develop the proof, the record that it is in fact perjury. If that's, not something that you've already developed and already kind of presented in the course of the trial. Somebody says something, we can go back now after the fact and prove that that's incorrect. That can come up in post-conviction in a couple of ways. One, because either we can say, hey, the defense team had this impeaching information, this contradictory information, and they never used it. Whereas had they used it to impeach this witness at trial, that could have, undermined this witness's testimony and changed the outcome. So it is ineffective assistance not to have done that. Or if it's not something that they already had in their possession, it is new evidence, then that typically is an independent basis to be able to come in and ask for relief. Like, this is new evidence. We didn't have it available at trial. We couldn't have used it if we want to. It has the potential to change the outcome, so it warrants a new trial.
So what happens then? Okay, so let me just give you this little scenario. You have a witness who takes the stand, who testifies about driving a specific vehicle around a specific path at a specific time, but the prosecutor and his entire investigative team know that that is an inaccurate and essentially perjury being taken place on the stand. They allow it and utilize that to benefit their case. Mm-hmm. Where does that fall? Appeal?
You got to have a record of that. You got to have a record of that, and you got to substantiate that. And so I know what you're getting at, because you're getting at the video. You're getting at the surveillance video from the property. The issue with the surveillance video on the property from an appellate standpoint is that there is nothing in the court record that tells us that these timestamps are accurate, and that is going to be a fundamental foundation to establish that that the prosecutor knew that wasn't true. So you can do that through post conviction after the fact if you have like an affidavit or whoever collected it, somebody can attest to like the correctness of the timestamps. But if that's not already in the record, it's not going to be something you can use.
So take away the video and just go with the fact that you have the documentation from Nick himself and his investigative team who state what time Brad Weber arrived home, and then you have that they pull the data and have him connecting to his Wi-Fi at a specific time that matches the time that in all their investigative reports up until trial show that he got home at like 2:54 or whatever the exact time is.
But prior to trial, his alibi was that he wasn't there yet.
That is already documented. And then you have a prosecutor who allows that witness to perjure themselves, knowing that all of this is already documented and that he was not home at 2:30, nor was he arriving home at 2:30. So even throw out the video, but you know that he's lying.
This is kind of a tricky one, because the issue is that Brad Weber had the real back and forth, the real conflicts in his accounts and in his stories about what happened. And so that always puts you in a tricky situation from a perjury standpoint, because, believing one version of events over another doesn't necessarily make it perjury, even if it's like really convenient that you believe that one. And even if it seems kind of incredible that you might believe that one, but there are conflicting facts in cases all the time, and so the standard to show that it is perjury is quite high. In that particular instance, where I think there's going to be the most avenue for that to be fleshed out, if they want to do that, is going to be through the ineffective assistance of counsel route, because these are materials that were available to the defense to be able to use, to be able to bring that up and show, look, here's when he connected, here's a video of him arriving home, here's your own prior statements from the investigators, documenting that it's this. And so not using that had the potential to.
Well, didn't they try though? That's why they wanted to get Pohl here, because they couldn't get us, like, because of the 302 versus the ISP report. Is that part of that, where they did actually try before trial was
So
over, but they couldn't?
They tried to impeach Brad Weber with Pohl. They wanted to bring in Pohl to impeach Brad Weber. And Judge Gohl said, no, you can't do that because you didn't set the proper foundation to impeach him, even though they set a freaking textbook foundation to impeach him with his prior statement to Pohl. But it ultimately didn't end up really mattering, because they were able to elicit from him, when they called him back up on the stand the second time, he admitted that he had made that prior statement, and so it was out.
Okay.
There's nothing then at that point that Pohl necessarily could have added, because it just, there's no more need to impeach him. He's acknowledging that he made that prior statement. So I don't think that particular part of it is going to be able to come in or be particularly helpful. It's just one where, the jury heard him explain why he gave two conflicting versions, and they get to decide which one, if any, they think is accurate.
Okay, but the juror did say, it matched up because the van drove by. Well, that's because they thought the van drove by at a certain time that it absolutely did not.
But what the jurors say is never going to be considered in a court. It's kind of one of the hard and fast rules of review and post conviction relief and stuff like that. The jury, you cannot use what the jury says about the deliberation process to impeach the deliberation. It's untouchable.
So this is the last question for anything to do with the appellate court, and then I'll let you have any final thoughts that you want to add to it, or if the other panel.
Nick's interview at CrimeCon, he suggested Rick could not claim ineffective assistance of counsel because he wanted them back on after the Supreme Court of Indiana ruling. That's idiocy. That's one of the dumbest things I've ever heard. Whether he wanted them or not has nothing to do with whether they rendered constitutionally effective counsel.
I think that was something on social media that was debated a lot, and people saying, "Well,
because
but they made the rulings that it wasn't."
No, that's dumb. That preceded the trial, for heaven's sakes. Like, what if they showed up drunk at the trial, and just because he had wanted them 6 months before, it means that that they were perfectly fine, that he waived that? No, he doesn't waive that. By saying he wants them to stay on as his attorney. Now, it might waive any issue relating to, again, the fact that there was they were distracted, because of having to defend the whole situation, having to defend themselves against these attacks from McClellan and from the court about their competency and their ethics and all that type of thing. And
that reminds me of
that
Chelsea's
potentially was
question.
in conflict with him wanting to have the speedy trial, so it's very hard to manage those things. He maybe arguably waived that, but none of that means he waived his right to have them competently try the case.
Well, Chelsea asked earlier, and I know she's kind of kidding, but I am kind of curious. She said, "Can Rick argue ineffective assistance of counsel because Gohl found them sloppy and grossly negligent? Like, if the judge found them that way, could they use her as an example?"
They're like, "You want to trust Judge Gohl? This is what she said."
Yeah, right.
Is there a way to get that in there, or is it just? I mean, it is kind of funny.
No, and the reason why is because what she found them to be sloppy and negligent about was the securing of the confidential materials, and so it related to the leak, but that's not something that had if that hadn't happened, would it have changed the outcome of the jury trial? It's very hard to be able to draw that conclusion. So they wouldn't be able to show prejudice to the trial. Even if they went ahead and accepted Gohl's characterization of their conduct.
Well, I almost feel like every time we talk about ineffective assistance in this case, it's almost at the same time a good example of interference with counsel. Like some of the things that his attorneys were accused of being ineffective as a reasoning to replace them with counsel of Gohl's choice. It's like a constant theme of interference, and they're not able to do, they wanted to do this speedy trial strategy and they couldn't because there was all this interference of counsel. And the thing even about them being sloppy and negligent or whatever, that's I find that especially incredible because the state knew about a potential breach as early as August, and they didn't do anything until it got to the point of it being something that affected the families with the pictures. They knew that there was, because that work product was making its way back to the prosecutor, but they didn't
Well,
do
And
anything
that
about it.
pesky Frank's memo came out.
Yeah,
Yeah,
and they,
Frank's memo.
they didn't. Normally, if you're in that position, if you are concerned that there's a breach of discovery, especially if it's protected discovery, you would go attempt to plug that leak as soon as you found out about it, but they didn't. They waited almost a month and a half before they did anything, and it wasn't until people were talking about them on the internet. But that one drives me crazy because they didn't do anything either, and they said, well, they were trying to investigate it. Well, that's very interesting because the day that they both found out about it, when they were the last to know about it, by the way, the state knew about it for quite some time before the defense attorneys even knew. And they immediately contacted the court to get it situated to plug the leak. And the state had just let it go for a month and a half. That one drives me crazy, but it's because they were in a way trying to find a way to investigate them, to get them off of the case, to interfere with his counsel of choice at that point. It just seems like to me at least, one example after another of them, the state taking more time to go after the attorneys than to actually solve the case or present one.
Right.
Yeah, and it probably is. When I look at things from the appellate standpoint, part of the problem is that shit flows downhill, and the lowest status person in the courtroom, the one who is always easiest to blame, is the defense attorney. They don't like to blame the judge, they don't like to blame the prosecutor, but they don't really mind blaming the defense attorney that much. And so you kind of accept that as part of the gig, that you are going to be the whipping boy. And it's just it's part of what you take on. Nobody wants to be found ineffective. It doesn't make anybody particularly happy to have something like that associated with them. But I don't know any defense lawyer that I respect that wouldn't instantly acknowledge if they made a mistake, or if there was something that they could have done better that they didn't do. If there was any stone that they left unturned that might have been able to help their client that they weren't able to do. And yeah, even if that means it wasn't even really my fault, it was the prosecutor's fault, I just had to do it because of the prosecutor. But you know what? If I got to be the one to fall on the grenade, I'm going to do it because that's my job.
Especially when, as the defense attorneys, you absolutely are adamant that your client is innocent. 100% factually innocent. I mean, there's definitely swords to be, and they're going to Monday morning quarterback themselves regardless. At least they should be, so that they can be more prepared the next time something comes around. So they should be able to, pinpoint errors that they made pretty fairly easily. Okay. So I want to move on from the appeal. Andrea, thank you so much for all of that information and answering everybody's questions on that. We had one particular viewer who has sent us an entire list of her questions. So we do have that, which we love the questions. So that is not a knock at anybody by any means. And then I did post on my community wall for anybody that had questions that you wanted to write them down there, to put them there. So I know Sleuthy has
Sleuthy is about to be on camera, but I do not have my mustache. So I don't want to disappoint anyone. I just want to let you know ahead of time.
Okay. And then All Eyes has the ones from the community wall. So I figure we'll kind of go back and forth between those. And then anybody that feels that they have the answer, please feel free to answer it, and we can kind of discuss as we go along. So
real quick though, I just found something Sleuthy was asking about a minute ago. Before we go on, the thing about she was talking about in March, it wasn't the investigator. I forgot about this until I was looking up at March. It came from the 3-day hearings from Walla, Harshman, and Holman. That's who I have cited in here on July 31st. Walla received an inquiry from someone from ISP, but it wasn't an investigator. It was a forensic psychologist wanting to talk to her about RA. And it was about the Companion Plus program. They were contacting her to ask about that. And she, Walla asked RA if it was okay for her to talk to them if they had questions about him.
Is that Westcott?
No, this is not Westcott, but that is the only thing between, like, for the March, whatever, about the
Mhm.
investigator?
So I'll tell you that it was not about that. It was that to make matters even worse. So it was about her speaking to the lead investigator with regard to him making phone calls to his family. And he said that he had been calling his wife, and she said that she spoke to the lead investigator, and that he basically said that that's not true. And he's like, well, I don't give a fuck what they say, because I talk to her at least 3 times a week or whatever it was.
When was that
Um,
from?
so that's from Westcott.
Okay. Well, then that is, I don't even have that marked down. I'm gonna mark it down. I don't remember that part of it. That's crazy.
In fact, I can look it up. Let me type in lead investigator and see if that pops up.
Was that from the day she testified?
It's about her report. I'll tell you an exact day if you just, if Teresa wants to move on, I will tell you the
Yeah, you
exact day as
can.
soon as I find it.
Yeah.
No, you're fine. I was just going to tell you guys, if you guys want to start alternating between those questions, that way we can get them answered for chat. So like I said, I know All Eyes has the ones from the community post, and then Sleuthy has the ones from Carrie. Carrie thank you for the super chat. Is it an issue that the state presented? Why is that not wanting to pop up? Hold on, let me get it so it actually shows. Is it an issue that the state presented a case at trial that RA acted alone and now go out and publicly say they think he was connected with Keegan Klein? Like from a legal standpoint?
Yeah, from a legal standpoint, it's really not, because what the prosecutors say is an evidence. Now, from a political standpoint, it should be pretty significant, because your elected representatives are misrepresenting to you, what their theory of the case is. They proceeded to trial under this completely solo act by Richard Allen, even though it seemed like at the very outset that they were kind of always trying to tie him to Keegan Klein, and that maybe was even part of why he was focused on as a potential suspect. But from a legal standpoint, again, what the prosecutor says isn't evidence, and so might create some ethical complications. Did he misrepresent? Did he misrepresent facts to the jury? Did he, present a case that he didn't believe he actually had the evidence to support? That might be a problem, but it seems a little bit too vague to really be able to hang your hat on anything besides he's very wishy-washy and dishonest, and probably shouldn't be in a position of power. But that's ultimately up to the voters to decide.
Yeah. Uh-oh, T, you're muted. I don't know if you meant to be. T? Did she step away? Oh, wait, hang on. Let me see.
She
Let me
might
check
have.
private. She might have.
Oh,
I
she has
think
to pee.
she stepped away for a second. I just saw that. Okay, what is the next question? Or do you have one handy, Sleuthy?
Hold on. So there's a lot, but some of these are like timeline things.
Mm-hmm.
Am I muted? Okay, I wanted to make sure I wasn't muted.
Yeah, I hear you.
So Carrie had a ton of questions, really good ones.
I bet.
Oh, okay. So this, I guess this will go towards the defense too. So one of them, I'm just going to read the whole paragraph. So she said, what efforts were made to try to get Richard Allen's phone data without the physical phone? It seems like none. Why the heck wouldn't either side do this? I know the defense has no obligation to do anything, but their experts said it was possible, and it seems like this would have been something worthwhile to focus on. Along that line, my question would be, could that be considered ineffective? Also, could it be considered ineffective that they seemingly put no effort towards trying to actually track his movements for that day?
Yeah, very, very much so. I mean, defense
Mhm.
does have duties. They have duty to investigate. They have a very well established constitutional duty to investigate, and that includes conferring with the appropriate experts as needed. So if they don't have a sound strategic reason for why you didn't do that investigation, then that is very much potentially ineffective assistance of counsel. So it's the kind of thing that it can put you in a little bit of a you're in a catch-22 situation, right? Because now you've been convicted, you no longer have the subpoena power to be able to go out and get that type of information. Why? Because your attorney never got it in the first place. So the challenge is going to be, how do you get yourself in a position where you can actually get that information so it might be able to be of some use to you? And you know, that's a problem that may or may not be able to be overcome.
See, I have a list because I saw that question earlier and I made a list of stuff. There's very few even mentions about, you know, I guess in his opening statements, Baldwin picked up a phone and was like, this phone doesn't lie. And we were all under the impression that by the end of trial, we were finally going to see or hear what Richard Allen's phone said or where it placed him. And we didn't. But there's very few things, like in the discovery map from December 2022, there's an entry in there for a search warrant on Ting and a search warrant return. That is the only thing showing me that law enforcement at least requested them after he was arrested, but defense never brought it up. And I don't know if they were planning to at trial, even though it was lemonade out. So maybe they were going to try to find a way around it. But the closest we got at all at trial was Holman and Doolin mentioning that phone records and the tower data was checked and he didn't appear in it, but they didn't specify whether it was the geofence at the crime scene, which was actually geolocation data from Google, or if it was the subpoenaed tower dumps that they got in the very early investigation. They didn't clarify any of that.
Ting would have been different. Ting would have been specifically his phone. The towers are like Verizon and AT&T, like, and Sprint, I think. So
was that to try to find his like identifier number?
No. Those are those. Wait, you mean for Ting?
The warrant might have been to confirm the IMEI. Do we know?
All
what
it
the
says
warrant
is the search warrant and search warrant return listed in a discovery map. It's just like their table of contents of what they had gotten, and that was listed in there. But other than those two little entries in this discovery map, we've never heard anything about it, and we didn't even know that, because we've always wondered, did defense even get his records from the phone company? Did anybody get them? Did law enforcement? And they did, but we have no idea what it entails, how limited it was, or how extensive it was.
So
normally,
I mean, that could be stuff like his location, his connections, the timing advance data, all that type of stuff that you get from a cell service provider to help do location. That could conceivably be what it is. It's just you know, it's kind of a guess if we can't see the warrant itself.
Yeah, and it's hard to even know if they requested it after he was arrested, because at that point, the return could have just said, "Sorry, it's been too many years." But they did in the lead sheet where it says cleared, right over where it says phone information sent to ISP, nothing further, which indicates that is why they cleared him. I do wonder if they requested it from his provider in 2017 even, or if it was something, you know, like it doesn't specify. I don't even know if it would have been possible, or if they were that extensive in 2017 about checking people who were in the area that day, who placed themselves there, because there was a bunch of people who went there that day that said that they were followed up with several times, and it was very intensive. So they could have, but they just didn't clarify. So if they didn't clarify at all in the record, whether it was a filing or trial, is that a problem for, I guess, trial counsel where they should have, or is it just, we just really don't know without seeing the warrant?
Yeah, I don't know that we can know without seeing the warrant. You know, what avenues they should have gone down, or you know.
Okay, let me see. I'm trying to look through the other questions too that I got earlier. Tried to mark them. Hang on, is Huda still in here? She I haven't seen. She was like, I might need a phone number to call in because she's got so many questions.
I have a question. I have a question for Andrea. Would you have ever stipulated to the chain of custody
Yeah.
on all of this evidence?
So this is an I don't know. And part of the reason why is because I don't know what the horse trading was. You know, chances are pretty good because these stipulations went both ways. You know, is there something that I got out of this stipulation that I might not have gotten otherwise that was worth trading off the phone? Because I don't know that I can even, you know, make anything real good out of the lack of chain of custody of the phone anyway. I don't necessarily have facts that I can point to that are strongly, you know, indicative of interference, and I have to be very careful with that anyway because who exactly am I pointing the finger at? You know, it's going to be very, very touchy in front of the jury. If you don't have real solid evidence of who probably did what, to be pointing the finger in certain directions. So this is one of those things where it's a strategic decision, and I don't know what the reasoning was behind it because you probably need the big picture.
Were you I don't even know if I can't remember if it was a sidebar or not, or if you would have even been able to tell if it wasn't, but they were talking about not just a stipulation to the phone, but even the images of the phone talking about the chain of custody on it. There was a
Mhm.
sticky note that said February 2024. Well, we were told that Cecil didn't start his other analysis until May of 2024. And there's no record of who was looking at this phone in February of 2024. We still haven't found out who that was. We
Wasn't
just
it
know
Bunner?
that, well, we don't know. He did
No,
stuff.
that was February 2017, Bunner.
Oh yeah,
Yeah,
yeah.
but the sticky note, because Goal got a question from the jury about the sticky note showing February something 2024. I don't remember the date in February, but it was 2024. And Gold didn't even ask the question from the juror because in the sidebar, I think it was a sidebar. Gold was
It
like,
would
well,
have
y'all
been, yeah, fair.
stipulated. So no, I'm
Yeah.
not even going to read it. So a juror had a question that didn't even get answered because of that. But to me, that's incredible because who was looking at it in February of 2024? Where's that
Yeah.
report if that wasn't Cecil's? Because he said he didn't get started until the weekend of his deposition, which was months later. So who else was pulling this thing out to look at it? Because it looks like it was physically checked out.
I've,
That seems like a
so
big oversight.
I'd have to look, but I feel like there was a February 24th of 2017 thing. My biggest thing is how can you say that the power off log is overwritten because once it died, you know, they restarted it 5 or 6 times or whatever and they overwrote it. How can you say that when there is power off, power on logs prior to that day? Because it deletes the most recent, not the oldest.
Well, even
That's
before it
unusual.
disconnected from the tower, there's like a series of power log, power log, power log, power log. In Cecil's 2019 report, that the Exhibit P, there's almost 20. It shows power log, power log, power log, and then it shows the status of whether or not it's connected. Like that's even just in that. I know Ajay said she distilled it down, and that was just, I guess that was just from Knowledge C, but there was a whole bunch of those in there. And I would think with that many power log events, you're going to lose a whole bunch of volatile files just from that alone. And there was a bunch of forwarding events where I assume it was trying, like, to me, I would think those are crash reports. I don't know if that's because it was water damage or if it was something was going on with the network, but I don't understand why those are recorded but not the last ones, I guess. But I guess we also
I
can't know.
remember I remember what the post-it thing was in the chain of custody. It was a sidebar. I think she was asking whoever it was on the I'm assuming it was Bunner. It must have been Bunner. She was asking him about the post-it and stuff, and there was an objection, and they had a sidebar. And she was going to ask that, and Gall said, "You stipulated to chain of or maybe it was Diener that was like, you stipulated to chain of custody." And Gall was like, "If you stipulated to chain of custody, why are you asking about chain of custody?"
Oh, I guess it's
Yeah, I
pretty
do remember
weird.
that. I do
Hmm.
remember that. I don't remember if that was about the phone. But I remember that coming up where Jennifer Auger was trying to kind of ask some questions about that, and she got spanked by the judge because of the stipulation.
Okay, it's written weird though. It says 17-2-24. And so it looks like it could be February 24th, 2017 or February 17th, 2024. Like it's written out of order. Even when most people put the year for it, like it usually would go year, month, date if they're going to write it in that way. But it says 17-2-24 and it just says Delphi PD victim phone. But in testimony, it shows that nobody touched it on that day. It was the 15th, the 16th when Chapman wrote his report, and then the 17th and 20th and 21st, I think. But that's a whole other day that is not accounted for either. This drives me crazy, not being able to figure out who was looking at it, and because that does affect what the phone shows.
17-2-24.
Yeah, it says like the number 17 dash and then 02.
So that could be
24.
That's February. That would be February 24th of 2017.
Okay, did they just mix up the last two, like the order of the last two numbers? Oh,
okay. Grayspace is saying that's February 17th of 2024. I guess it depends on what country you're in.
That's my question. I'm like, who wrote? Like, we don't even know. I guess maybe it was Bunner, except I don't know why you would ask anybody else unless it was Bunner, but that would have been 2017. But it just drives me crazy. Like, what day was this? We can't even ask because they stipulated.
I'm gonna tell you. I'm gonna tell you this because I was looking at Carrie's questions, and one of her questions is, "Do we know if any tips were cleared based on height, not being tall enough?" I will tell you emphatically that the answer is yes. In fact, I don't know why it wouldn't have been brought up that there were people cleared because they were 5'4" and that was too short. Okay.
Wow.
And therefore didn't fit the description. So there is a plethora of so-and-so doesn't fit the description. They're too tall, they're too short, they're too fat, they're too skinny. And they don't show up in the tower dump, so they're cleared. So Rick should have been cleared for a number of reasons, one of which being he's 5'4" and that was too short according to them. And his phone didn't show up in the tower dump.
Which is how other people are cleared.
Correct. So why are we bringing someone in saying that they were there, committed the crime, fit the description of all the sketches, the old ones that's also fat and also skinny and also young and old at the same time. But other people got cleared because they were the same height as him and they were too short.
Well, it's kind of like an alibi. It is whatever the police say it is. At whatever given time they say it, and if they do a 180, they will look you in the face and act like you're crazy for thinking there's anything weird about that.
Yeah.
They do it all the time, and it's very frustrating, especially with alibis, because even if someone has a really good one, they will find all kinds of reasons to dismiss it or to act like it's not really, super solid and
it would have been easy to fabricate or something.
Yes, and then if they want it to be something because it would be a problem for them, then all of us, or people who
because of course the hospitals just have cell phone blockers up everywhere.
Right.
Like, of course, that's a totally normal explanation that we'll just take at face value and clear this guy.
Pretty much. Very frustrating. Let me see. I just realized I can type this in chat so I can show how it's written. I think it's long past, but I just saw Grayspace's thing. I just wrote it in chat though, how it's like the order that it's in. It's weird.
So I hope everybody takes that. I hope we all realize what's going on here with this short person being excluded because they're short.
Mm-hmm.
Someone said, so this is Carrie again. Explain the logic of the bullet in the keepsake box. It makes no sense to me. It seems like it would require Richard Allen to have known that A, he lost a bullet,
Yep.
B, he lost a bullet at the scene, and then C, decide to take another bullet and store it in a special place as a reminder of killing 2 girls with a knife.
Well, it also doesn't make sense where if he carried one always chambered, the place they're saying that he racked it to coerce the girls, that happened at the bridge. So how did it end up across the creek in the dirt?
I've had this issue forever. Oh,
And then even if
you
and
know
then
me with this.
let's
It
say
doesn't make any sense.
I know. And then let's say he
the
didn't
girls
have
are
it chambered.
dead. Why are you racking your gun where the girls are dead? Or
That-
why are
yes.
you racking your gun if you're in the middle of killing 2 girls with a knife?
Yeah,
There's
like
no
is he a
reason for
ninja?
it
Like how did was he
over
holding
there.
one in one hand? Did he put one away and then pull out the other one? But like at the same time, like he needed that at the bridge to coerce them. But on the other side of the creek, he was using a completely different weapon, and he already had their submission at that point. But still, even if he didn't have one chambered and it didn't come out because when he racked it to scare them, then it chambered it, and then it came out. Okay, well then he kept another one. Like so. That still with the math where they were trying to say how many were missing from his magazine, that doesn't add up either. I don't think there's any rhyme or reason to it. I think it's just something they continue to fill in the blanks however is convenient. And they were never forced to account for their assertions with that. And Miss Oberg was able to get up there, even though nobody is right 100% of the time. That's not a thing. She's allowed to get up there and say it as if it's true and she was correct, even though she wasn't. Her own work product, according to Warren, showed there was an insufficient agreement. So that whole thing irritates me. Everything
She
about
didn't
it.
even want the jury to look at the pictures.
Yeah. And Goal only admitted it. And she's like, you can look at it just for the sake of this is part of her process, but you're not allowed to use your own eyes to look at it to see if they actually match. Like there was a very weird.
You may not believe your own eyes. That just summed up
Yeah.
this trial. This was the gaslighting trial of the century because you are not allowed to use your own eyes. You must just accept what the state tells you.
It's infuriating. And they're like anything that contradicted the state's theory, Gold just kind of was like, you're not allowed to do it. It's not admissible. And unless it supports the state's theory, you don't get to talk about it. And then even with the stuff, she would say you can cross-examine them, but she didn't allow them to have an expert that could have come in and been able to, from an expertise standpoint, challenge it. And it's just all they could do was have Warren say it was insufficient.
And one of the issues that I had with that too, the problem with excluding the metallurgist is because, that went to the whole validity, the underlying validity of what she did, right? Because she compared the gun, the bullet that had been cycled through the gun with the shell casing that she fired from the gun in order to create, deep enough impressions to be able to make a comparison. And so the metallurgist is the one that has the expertise to talk about what is the effect going to be on that metal by this pressure and this heat and these gases and so forth that are incident to firing a gun. Hi, Lilith. and so if you're going to have any sort of basis to challenge the entire methodology is unscientific, not just for the jury, but just for purposes of being able to admit it in court at all. Like you don't get to just have somebody say, I'm a scientist and therefore, I get to present you whatever I want to present you. Like there has to be some kind of floor that this is, at the very least, it's accepted by experts in this community as a technique. But in, better jurisdictions, it's that, there is an actual like valid, reliable methodology that's at use in what you're testifying about. And so she deprived them of the opportunity to even be able to evaluate whether this is sufficient to constitute science to come into court.
I'll tell you, I found it more compelling that they had an expert who didn't just say, like, they didn't get on the stand and say, what she did is garbage, like I would have said. He said, this is valid. We can use this when we're doing it the right way and we're comparing it to things that are similar rather than to totally different things.
Yeah.
And I wonder, as someone that was sitting there with the jury and listening with them in real time, did you feel like there was a good explanation for why he didn't do a report? Because it's my understanding that basically he's like, why would I do my own testing and write a report for something that's just not, it would have literally been a waste of my time because
Mhm.
you can't do it that way. I can't compare her fired round to the unfired round. Do you think that it just looked like he just didn't do it because maybe he knew that it would match?
Well, no, I think it. I mean, it did come out as shady. You know, it ended up coming out as shady because they needed to give some explanation, and I had a pretty good idea of what the explanation is. Number one, you're funded. You know, your funding is dependent on what the court says you're going to be allowed to do. So it's not up to the defense to even say whether we're going to do this or not. It's ultimately up to the judge to say if
Right.
we're going to be able to do this or not. So I don't know if that was even, explored as a possibility with the court, if that was one of the requests that was denied or anything like that. But they really did need to have some kind of explanation because it just ended up making them look shady. And you could tell from the jury's questions that they thought this guy was shady. They thought the whole thing was super sus, that he was like a hired gun for the defense. And they just weren't buying it.
And also with the whole him saying that there wasn't sufficient agreement, I feel like you could have harped on the fact that I don't need to do my own. I'm looking at hers and I'm telling you that it's not sufficient. So she already did the work for me. I'm just looking at the work she already did. And I wonder if juries just have this need for you to, like, if you don't repeat the same tests over, like, is that where we're going? Like, where if you're not repeating the same test and both of you get the same or opposite things, then we're just not going to believe you because you didn't do
Yeah,
it?
because even the juror said, even with the Cecil thing, she's like, "Well, why didn't defense? All the state had to do was go and Google it to refute what the state was saying. Like if you,
I
they
can't
they
believe that
do
was allowed in.
me
It
either.
seems
But
so
like
small.
the juror, at least for the one in this case, she did say, "Well, why didn't they have a report? They didn't even do anything with it." And so I guess they did expect something like that.
I think experts, I mean, just my experience with them in trial, experts are the kind of thing where they don't necessarily weigh a lot with the jury in and of themselves. Like the jury expects that the experts are biased. They're there
Yeah.
to, present the perspective of whoever is putting them on the stand. And so they just end up believing whoever they, ultimately end up believing overall in the case anyway. The experts just don't tend to really be that influential in terms of actually swaying the opinion one way or the other.
Mhm. Here's a good one. And so this is like this is the thinking of someone that's like just coming over here and jumping into this case. And again, it's Carrie, and she said, "Is the state's theory that the girls were dead by 2:32 p.m.?"
Mhm.
Yep.
The answer is yes. Neither
Yes.
side seemed to pinpoint this at trial, and it's me. Okay, we don't. I won't read all of her commentary, but it says, um, it seems like the state danced around it, but in closing, they went all in by saying the phone stops moving at 2:32. It's underneath the body of Abby Williams, and basically said she did it deliberately to catch her killer. That means all of this had to happen in 19 minutes.
Yep.
Abduction, going down the hill, crossing a creek, taking off clothes, putting
Mhm.
on clothes, keeping one girl quiet while cutting the other's throat, which still baffles me. I don't know what if they weren't, if neither of them was bound in any way. I don't know anyone who would sit there and watch one be brutally murdered in the open and not run away.
Mhm.
So that right there
Yeah,
just
or
makes
scream.
no sense. They have no reason to be quiet. You can't, when you see that, you can't think, "Oh, if I just comply, then they're not gonna hurt me," because now you're seeing you've complied and they're hurting her. So there's
Mhm.
no incentive not to scream. There's no incentive not to try to run.
Well, we're gonna fall right back into Dylan Mortenson's situation here of this whole, fight,
She
flea
didn't
fight.
watch someone be murdered.
Well, even aside from that, though, he was outnumbered. Libby was this.
They
They
were the
both of
same
the girls were
size
the
as
same.
him.
Yeah, they both of them were the same height as this man, and they were in better shape than he was. Libby was an actual swimmer, and the man had a heart condition.
Right.
And
That
you
yes.
can't even pay him to order people around. When the day West got testified, she even
Yeah.
spoke about that when she's interviewing Kathy. He continued, like, there were several instances where he took demotions because the anxiety of having to order people around was too great for him. Like he didn't even like that. And I kind of relate to that sometimes. Like, it's not that I'm bossing somebody around, but I don't like to micromanage anybody. Like, I'm just not going to do it because I just have too short a fuse. But with him, it was like an anxiety thing. Like he really couldn't even do it for money. And so the notion that he's got a heart condition, debilitating anxiety when it comes to ordering people around, he would have had to wake up and develop an entirely new personality, because this is something he couldn't even accomplish in daily life. Even if you're like doing daily affirmations for it, like it's still something you cannot do when it comes to performance when you're working. And that's what people that liked him, they said he was a great worker. He was very polite and he had good reviews. But even if you can't go with how little time it took or whether the victims would have cried or not, I also go back to water is not going to comply. They were going through water and it was high enough to where you can't whisper through a creek. Like if there's 3 people crossing, it's going to cause some commotion and it's going to draw attention. And we know now that even right before 2:30, there were people that were still on the creek. So had they crossed immediately to do all of this, like the state says, Betsy Blair was still on the trail and David Riley was getting there and his dog was with him. Like the dog would have been causing commotion. Even if the people didn't hear it, the dog would have.
But you also have Dave McCain, who's out there taking photos this entire time. Exact same time.
So even if the girls, I don't think they would have been, and the water's freezing. I don't remember. I think it was Cryptex's live where we were talking about it. Like I tried to do one of those ice baths one time, like a legit ice bath. And it just like I think my analogy was like I made less noise when I was in labor than when I got in that ice bath. Like I just couldn't help it. Like I just was so shocked. That is involuntary. You know what I mean? Like there's just so many things, even if you don't go with what the victims would have done, like just any human, you're going to have a reaction to that. It's going to generate noise and commotion. And especially with a dog on the trail at the time, I just can't wrap my head around it. And he was outnumbered. How did he get these girls compliance and do it that quickly? Even if they were silent, time-wise, like it makes no sense.
The piece of the picture that made the least sense to me was Abby's hands.
Yeah.
Pristine, like literally, the clean that your hands are when you first get out of the shower, before you've touched anything at all. That was her hands. And we heard from the blood spatter expert how, when you have a wound, your instinct, you're not even going to think about it. You're going to put your hands on it. That's he was explaining why Libby, had the blood patterns that she had, and Abby had none of that. And I don't know how you account for that in this crime, the motivation for the crime, the time frame for the crime.
Well, how are her hands clean?
Abby would have touched her throat, right? According to the blood spatter expert, and somebody took the time to clean her hands extremely thoroughly, like
and then
her
fold them.
And they were climbing a muddy thing. Like if they had gone over the thing, they would have had to climb up that little. I mean, it's like 6 feet tall that they would have had to climb their way up. You're going to get mud in your nails. Even if she hadn't touched her wound, but like all of these things. And how is she washed and pristine? And then there's still hair around her pinky.
The hair.
I can't, like, I have too many questions that I think need to be accounted for. Even just the disparity in how the girls were treated. This is not a sufficient answer. And if this is something that can happen to 2 girls, like we need to understand why, especially if you have any concern for preventing such things in the future, you have to understand how these things happened. And if you don't even know what actually happened, how do you safeguard people in the future?
Never prevent it again.
Yeah, it bothers me. Like on a mom level even, but like just as a person, as anybody, like you gotta, like, I know we're not ever gonna get every question that we have answered, but the important ones should be accounted for. And I don't even think we have the basics with what actually happened to these girls.
Yeah, I agree.
Who's got the next question? Do you want me to pull one from chat?
Yeah.
While she's looking it up, DB sent me a message and said the sticky note, it was formatted year, month, day, like for the digits. He said it's an ISO date.
Okay, so it was February 24th, 2017. Okay. That's
They
what I
can
thought.
be.
That's how I read it.
Yeah, I had a feeling it sounded familiar when you were saying 2 and 24 and 17. I was like,
Well, I was confused because of the way the juror asked about it, because Gold didn't end up asking it. So I'm like, wait, is she saying it was actually 2024? Like the way it was brought up in the transcripts, at least in the sidebar, that's because I thought it was initially 2017, but the way it was phrased, it just made me think that we didn't actually get clarification on that, but I guess we did.
you know, I have a difficult time understanding if I was a juror, I'm sitting there. Let's say I'm bringing in expectations of what I knew of like TV shows where someone's testifying and someone's at trial for murder and they like point at the person and they're like, that's the man I saw. You know what I mean? It's like very
Yeah.
dramatic
Right.
and stuff. So like, I feel like as a juror, if I was sitting there and I'm seeing these, I think there were at least 3 witnesses that are coming up and they're like, I saw this bridge guy. He looked like this. He was, I did say that my head was up to his shoulder and I am 5'7" and clearly that's not Richard Allen. And nobody asked.
Mm-hmm.
And therefore they didn't say that the person they saw was Richard Allen. Like not even an accidental, like ask your client. I saw your client.
Yeah.
It was the defendant. Like not even an accidental, like nobody at all even hinted that the person they saw was Richard Allen.
Nobody
No,
has
they
ever, not even just at trial, but almost 10 years in, not a single person ever said, this man, Richard Allen, that's the person I saw. They've all
No,
said,
it's
like, the
almost the
person from
opposite.
Libby's video.
They all describe somebody who doesn't
Mhm.
actually look like Richard Allen.
Right.
Mm-hmm.
I also have a question on that because this is another, I can't tell if it bothers me or not, but at trial, because it was the first time I heard it at all, Cheyenne even said the description of the demeanor of the man matched exactly what Riley said about the man. I think Bree
She
and
said
Riley
hi and
testified to this.
everybody
Yeah, and he
says
didn't say
hi
hi
and she was
back,
Yes.
and he was cranky and he was rushing right by me. That
Mhm.
means that and Cheyenne even said, I believe that the man that I saw when I went to law enforcement was the person from Libby's video. Well, law enforcement decided that the person she saw was Dave McCain, but that makes no sense because when they talked to
So
Dave
Dave
McCain,
McCain was acting the same way as a bridge
yes,
guy?
but
Is that what we're
Dave
saying?
McCain says he only saw Shelby and Daniel. Cheyenne said she walked right by him, and he's like, nope, I didn't see her. I only saw the couple.
Well,
And so, how
just
did
think
law
about
enforcement
the fact
resolve that discrepancy? That is a big
who's
problem for
wearing
me.
a weird hat? Who wears that weird smoker's hat? You know what I'm talking about?
Yeah.
Who wears that?
Besides Brad Holder.
Well,
Is
besides
it
Brad
this
Holder,
hat?
yeah. But I
Do
mean,
you
Dave
think I'm a
McCain, his
killer because
photos.
of this hat?
Well, I mean, you
Who
have
has
a
the
witness
scarf
coming
on
forward
in his
saying, I saw
photos?
him
I mean, yeah.
afterwards. Like Cheyenne would have seen this person regardless of who it was after the video was taken. And when she's saying, hey, I saw him, and you ask Dave McCain, hey, did you see her? And he's like, nope, I didn't see her. I only saw Shelby and Daniel. And now we're realizing that Cheyenne said she didn't just like see him in the distance. She walked right by him, and he's saying he didn't see her. To me, I'm like, okay, that's somebody on this trail that's unaccounted for.
How
And
did
they
she walk
never
right
even
by
looked
him?
at it. She said she was walking towards the bridge, and at that point in time, he was walking back towards the trail split. Like when you piece it all together, she said she passed him.
But wouldn't he be murdering at that time?
I don't know, but that's my point. Like when at this point in time, law enforcement is not even, because Nick went on HTC's interview with them, and he even said, well, the descriptions conflicting with each other, that's not a problem. And what we decided ultimately was that it's actually they all were describing the same demeanor, and that's what mattered. And he's saying that was part of their reasoning for deciding that Richard Allen was bridge guy, but he's got another witness that's also saying the same description of the same demeanor, and they're dismissing
Mhm.
it.
And they're calling him Dave McCain.
Mm-hmm. Like by their own logic, they had another person on the trail unaccounted for. And I do think, though, that is why so many times people are saying, well, maybe that's what happened with all the Daniel Pearson stuff. People were like, well, who did he see? It had to have been Dave McCain. And then actually maybe Betsy Blair saw Daniel Pearson. And that's where all the confusion was, because they're all given different descriptions. Well, the one thing that is consistent is the demeanor of someone who said hello and didn't say hi back. And so, but to me, I'm like, okay, well then how come Riley and Bree didn't, how come they saw a bridge guy but not Dave McCain?
Well,
And-
because they
No
knew
one saw Richard Allen. That's what matters to
Well,
me.
because
No
he
one
was
saw
gone before the
Richard
girls were
Allen.
dropped off.
Yeah.
No one saw Richard
Right.
Allen. Richard Allen's phone does not put him there. No DNA puts Richard Allen there. No eyewitnesses will put Richard Allen there. No video surveillance puts Richard Allen there. No,
It's because he left before the girls were dropped off. That is what
I-
all the state's evidence
here to tell
actually
you-
points to.
I don't even have any evidence that he was even fucking there that day. Like, I don't even know that I believe his ass that he was even there, because there is literally nothing that I have seen other than him saying he was there
Yeah.
that shows that he was there. He's not on the geofence. Again, no witnesses saw him. No witnesses saw his car. Didn't it have like a cat license plate?
That's what when he was in his first interview, he was trying to explain to them that Kathy drove that car on a daily basis back then until he got her the van, and it even had her little kitty license plates on it at that time. Kathy, when we read her interview transcript, she seemed a lot fuzzier on it, but she was very open about how she couldn't keep it straight. She's like, I don't remember because it was so long ago. But that's the kind of thing he remembered because he's a wife guy. I mean, he was talking about, yeah, she drove that one because it was nicer. So I drove the older one because
We
that's the kind of
also-
stuff he did. And then he got her a van because even the Ford wasn't new enough for the wife guy. So we got her a van.
We might even we saw in Kathy's interview, whatever that is that we read with
Mhm.
whoever that is, we even see her in there saying that they're talking about this blue jacket,
Mhm.
which I am positive is not a Carhartt jacket.
I have
But-
never seen duck canvas drape the way it does in the bridge guy. When you look at all those early videos, it's almost like you
It
can
looks
see
like
an
an old man
outline.
windbreaker. It's a windbreaker.
Yeah, because of the way it drapes over stuff that's in his pockets. Even a Carhartt's not going to do that. Even
But
just the material it's made out of, it doesn't drape like that.
She says in the interview, no, those Carhartt jackets make you puffy, trust me. But she said in that interview that they had just bought this jacket like 2-3 years ago. Well,
Yeah.
this was 5 years after the crime,
Mm-hmm.
which would mean that the jacket was bought after the crime. And I had heard rumblings like right after the trial, maybe during, I don't feel comfortable saying that, but I know it was right after, was that they like had a receipt
Mm-hmm.
that the jacket wasn't even purchased until after the crime. So they showed this jacket to the jury, right?
Mm-hmm.
Andrea, they showed
Well, the
them
picture of it.
yeah, the
Yeah, the
hanging.
picture.
Okay, so I think it would have been really compelling if they would have then turned around and said, he didn't even buy that. Here's a receipt that he didn't buy that jacket until after the crime, so he couldn't possibly have been wearing that during the crime. But would they have needed to have that come in via Kathy Allen? And for Andrea, what are the benefits in this case, and then potential bad things, because it was a long day at work. I can't even think of words. The potential negatives of having Kathy testify, and just as a hypothetical and a roundabout guess from you, do you think that you would put her on at the second trial if there were one?
It's a tough call, and it's not really one that I could make without knowing these people, without knowing who they are, how they present, how they're going to react under questioning, how they're going to be able to handle cross, and just, above and beyond like what they would actually say. I don't know. I haven't interviewed them. But as far as like the trade-offs go, the challenge is what you open the door to, as far as cross-examination. We saw how Nick was, and his way of handling the witnesses. He is a bully. He's a gaslighter. He puts words in people's mouths. And so how well is she going to stand up under that? What kind of effect is that going to have on her? How is she going to come off, just kind of as a matter of overall demeanor? You potentially open the door, to questions that maybe, aren't helpful, maybe aren't good to ask. Like, what kind of mood was Rick in when he left, his family's house at lunch? Maybe he was in a bad mood. Like, just, things that can be taken and twisted and distorted. At the same time, you can't really, like, you can in theory call her for just the sole purpose of presenting this receipt and nothing else. And then you limit the cross-examination to the scope of what you brought up on direct. But then you run the risk of looking shady, because the jury is going to be thinking, well, but here's all these things I would have wanted to ask Kathy. Why didn't you ask her any of those things? So it's a real double-edged sword. There's a lot of strategy that goes into making a decision like that. That without having all the facts, you really can't second guess a decision like that without knowing the big picture.
Well, I didn't realize this until we got the transcripts that she was going to testify, and it wasn't a decision by defense to not have her testify. It was more of a matter of the Google searches, trying to get them in. Gold took it under advisement, or I don't remember. Ajay asked to limit something. I can't remember now off the top of my head, but Nick he wasn't even able to sneak it back in until right before they rested. And so I don't even know if there would have been time to question her, but she was apparently prepared to testify, according to Ajay. And I don't remember if this was a sidebar or not, but Kathy was going to get on the stand and say, those were my searches. And when we finally got that exhibit and you look through it, it really was just somebody looking through the newest updates from the Delphi trial. And when you look at the time frame, like the dates that those searches were made, it was right around the time that they were making big announcements and updates about somebody they're looking for on social media who was catfishing the girls. And so, I mean, it would have been pretty weird for somebody not from that town to have looked at it, but she was prepared to say, this was a shared computer. Those were my searches, but she didn't even get to, because Ajay requested something to be limited, and then Gull ended up just sitting on it until right before the state rested.
How did those searches get in, Andrea?
I don't have an answer for this. This was baffling to me, because they didn't even have, they didn't have a sponsoring witness. Like, normally to get evidence in, you have a witness on the stand who says this is what it is, and and you ask them some questions about it, and then it goes in. So you would have had an investigator being like, did you contact Google? Did you get records? Are these the records you got? Why were you interested in these records? What do these records show? And they didn't do any of that. They just literally, like, out of the blue, we've admitted these records, and so here they are.
Because Gold was like, I finally made a decision. She came back in. I think it was before they brought the jury back in. It was on the 31st. She's like, okay, I finally made a ruling on the admissibility of this. And I think Ajay and Nick both presented case law for Gold to consider. And between it was the day Vito testified about the search, and he was going through all the stuff because he was present for the search, and so they were admitting all of that stuff into evidence. And then that was the day that Ajay objected. They argued about it a little. They both presented case law, and Gull sat on it from the day they went over the search warrant until literally in the transcript, right after Nick admits it, it just says the state rests.
Yeah,
it was just because Gull finally made a decision. That's how it worked out. I didn't realize that until I read the transcripts, but it still breaks my brain a little bit.
How I understood it, listening to the live coverage, because obviously we didn't know what was going on.
Right.
I thought it was presented. She said no. And then I was like, okay, so the answer is no. Also, it didn't even really sound that bad. So it seemed like a waste of time and a reach, And then next thing you know, the news is telling people about these searches, and I was like, wait a second, how do they have these? I thought they weren't even coming in.
What I remember is that they were offered, I don't remember the context, but they were offered.
I'll put
Jennifer Auger had objected on an authenticity ground. There was like some argument that had to do with authenticity, and so Goal, they had like sidebar, I think, and Goal took it under advisement, and it's like basically, what you're describing. So there had been an objection, but it's still just.
I just found it in the transcript.
It's just strange to literally just drop a piece of evidence into the record without having a witness there, to identify it and say what it is and say what it's relevant for and all of that.
It was about let's see, Miss Auger says, Your Honor.
It was like his movies that he'd watched and stuff.
Stupid shit. Really?
It was the name of a Netflix series. Auger said it was the business record certification that was provided from Google does not contain any information about the proposed document that the state is seeking to admit. The document the state is seeking to admit is a police report by Detective Vito outlining certain internet searches. States 289, which is a business records affidavit from Google, contains no such searches. And so they still don't have what they need to authenticate what they're seeking to authenticate. But that's the point of contention that she had. And so then this is before the jury comes back in. And so Nick says, I'll have to review that, Judge. I thought those were in there. I've got to admit, I don't have it in front of me at the moment. So I guess I would just ask for a recess on that issue until lunch. And I'll look at it at our first break and verify that I gave the right copy of the certification and whether or not it's there. And then right before they rest, they talk about it a little bit more, but that is what halted it. But Kathy was supposed to testify that day. Like Nick was prepared to present it and Auger said not so fast. And that's the only reason she didn't testify that day. And then the state rested before she could.
Yeah, I did
Hmm.
remember her saying, like, basically that if he was going to do that, she was going to put Rick, or not Rick,
Kathy.
who the hell even knows if he was even capable of testifying? I'd vote no.
Right.
But she was like, I'll put Kathy Allen on to say that those were her searches. And it almost seemed like he was like, well, I guess we won't do that because whatever good it's going to do for us could be bad depending what else she's going to say. For instance, he was driving a different car. Maybe she was going to say, maybe he didn't like the idea of her saying that when she got home at 6 o'clock, he was asleep on the couch because he might think that a jury would be like, how the hell could you murder 2 kids and then go to bed and not be dirty and not need a shower? So anyway, but there was something else I was going to say about that specifically, and now I can't even remember what it was.
The one on screen. Thank you, T. I forgot. I wrote that one down.
Are we going to talk about the bridge guy video now?
That's what I want. That's what I have up. So I have.
Well, Andrea's like, really?
We're going to talk about the bridge guy video. Michael asked in chat, and so I'm going to bring it up. So, a friend of the channel had said that, with going through all of the metadata of the video, the orientation of how we got it to put up, like when it got put up like on the Richard Allen website, is not the same orientation as the metadata shows. So they put the video the way that the metadata is, and that's the video I'm going to play for you right now. And the question is, give me just 1 second. I'll take it. Thank you.
Delivery.
Brought me some chips and guacamole. So I'm going to show you the video the way that it is according to the metadata, which is what we're trying to figure out if this is how it was shown in court, because the media player may have tried to stabilize the other video that ended up on the Rick Allen Justice website. So that's what I'm trying to figure out right now. So I'm going to play this for you guys, but I have to mute, otherwise it'll echo.
Okay.
See, this is the path that we go down. There's no path going there, so we have to go down here.
Okay, so I'm going to take you back to like where the most important part of that video really is, and why I'm wondering if this is how things were shown in court, because this would explain why Andrea, Bob, people in court are like, we never saw Bridge Guy. Like it just was like, it didn't happen. Like we didn't see him there. Everything was like wonky. And so I'm wondering, does this explain the difference in these exhibits and what you saw at trial versus what we published months later?
It does not to me. I will let Bob speak for, you know, what he remembers and so forth. But there's a couple of things here.
I'll have
One,
the link there if you want to come up.
you can see him, and we could not see Bridge Guy. And you got to understand, we were all on pins and needles watching this, knowing what we're looking for, waiting to see Bridge Guy. We are staring intently looking for Bridge Guy, and we never saw Bridge Guy. And the way that I remember the video, what we were told was the original video from the cell phone. This is similar in the sense that it was being moved around, you know, and the perspective was changing. My recollection was that it was so like shaky the whole time that it was moving that you could barely make much out at all. And what it looked like, it had given me the impression that it was like the phone was in her hand and she had accidentally hit the record button. Like, you know, you accidentally hit the button and you don't even necessarily know you're recording. You're not trying to, it's just you're holding your phone. And so whatever you happen to be doing with your hand is what's getting picked up on the camera. That's how it looked to me. It was so, like I said, just very, very, very shaky, disjointed, not really pointing at anything. And no, like, we didn't see this.
Can you also
see
clarify?
Bridge Guy here. We could
Was it on
not
a big
see Bridge
screen?
Guy.
Like when y'all saw it, because we were also told that like it was very, y'all only saw like a teeny tiny little thing like way off in the distance from the back.
Wasn't it on the $90,000?
Wasn't it on the big screen? Because I've heard some people say, well, y'all probably misunderstood it because it was just so tiny in the distance. And I thought it was on the big screen.
We saw, when they showed this in court, it was on the big screen. Now you got to understand the orientation of the big screen and your ability to see it depended on where you were sitting in the courtroom.
Okay.
Because it was lined up for the jury to be able to see it. They didn't give a shit about us in the audience.
Right.
Like they didn't necessarily want us to see anything at all anyway. So there were plenty of times where like half of the courtroom would be behind the screen and you wouldn't be able to see anything at all. Or like the closer you sat to the door, you know, you might have a better view of the screen. So we didn't necessarily have, you know, the best view of all of this. But again, like we were intently looking for this. We knew this is what was there, but we never saw it.
So I have a lot of problems with this. So my first issue with this is, well, I'll ask a question. I know Bob felt like it was really fast. Did you feel like what you saw as the original video was the full 43 seconds?
No, I didn't. I thought it was closer to like 30. I remember that at the time thinking like this, you know, because I was still pretty new to the case. I hadn't been all that immersed in the background, but I did know this was supposed to be like a 40 second, you know, some video. And it did seem shorter than that.
Okay. So when all of this was going on, one of the things that I did was take the original video and I clipped out all the parts that have Bridge Guy in it. And it was about 30 seconds.
Well, in the transcripts, it does say the first, like it was showed twice that day. And the first time they cut it off around 30 seconds because they didn't want the jury to hear down the hill at first, because they didn't want to. So there was an issue with that. But then apparently after lunch, they did play it in full. So I've always wondered if that played into it as well. That's why that's where people were getting the 30-second thing from, is because the first time it was played was 30 seconds and the next one was 43.
So my issue is, I think that the reason that I think it's very troubling that they refuse to release the exhibits of this. So they refused to release the exhibit of the original that they showed and said was the original. They refused to release the stabilized version. They refused to release the one where they like did the clarity or whatever it is that they did, which I don't even think was explained very well to even understand what it is that they did to this video. Oh, wait, let me grab this before it goes away.
There's two versions of it, by the way. According to the transcripts, the first one is just the regular one. The second one, according to Liggett's testimony, when they played the stabilized version, he was the only one who gave any sort of detail. He said it was stabilized, and at one point they zoomed in on Bridge Guy in that version. And in that one, the tail end of the audio was enhanced by Chapman. So for a while, we thought there were three versions. There's actually two. And one is just plain regular one straight from the phone. The other one is actually stabilized. And Liggett said they actually zoomed in on Bridge Guy in that one.
So here's the issue. I know with 100% certainty, like if I could say more than 100%, that the video that's publicly available came from the not the report of the extraction, not the actual physical extraction of the phone uploaded into Celebrate Physical Analyzer. That is the video that was in the phone that was pulled from the extraction, is the one that was put out publicly. So like Michael's saying, if that metadata is correct, the one that we just saw, and it was like, the metadata saying that it was upside down, or any number of other things, the unsteadiness, anything else that we're going off, and it's very difficult to compare because again, they refused to give us those exhibits. How does that end up in her phone in an extraction that was done days after her death in 2017? If that's not the original, and supposedly it was flipped, Michael thinks the metadata doesn't say anything about the orientation. Maybe the metadata, I don't know.
I thought everybody, when it came out, was checking the metadata and saying, nope, this is exactly, there's nothing, like nothing's been changed.
The only thing that was different was the fact that in the metadata, and it's the same one that was the same lady that was in our live that night when we were playing the video, who was checking the metadata for us. She said that you can read it and it will tell you the orientation of the video. This is hers, that she's the one who flipped that and made it so that the orientation was the way that it was actually recorded on the phone, according to the metadata. Now, so, I'm not tech savvy, so don't.
Yeah. I'm not either. I'm not tech savvy either, but I can tell you that how it appears on the website is exactly how it appears in the phone extraction. So, if we're going to argue about what they were shown at trial, I don't trust Nick at all. I don't trust him as far as I could throw him. And I don't think I could even really throw him very far because he's so greasy. But I do not trust him, but I trust my own eyes, who saw exactly how that video exists in the extraction itself, which doesn't require anybody to tell me how it's, oriented or what the metadata says. It just is what it is.
Well, they can pick and choose what they put into the HTML thing. Like they can, they don't, if you're looking at the raw data, it's probably not going to be like in a visual format, but they can pick and choose. And it is possible, especially now that we know Bunner was taking pictures and opening stuff before he even plugged it in to image the thing. Like he could have accidentally flipped it or something and then flipped it back when he, when he's,
but then the metadata choosing in the extraction would change, right? Like it would say let's say it says the created time, and then it says the updated time.
Well, the reason you're supposed to image it is because you can change things. Do you know what I mean? Like it even says in the metadata that I first saw when people were doing it, there's I don't remember if it was creation date or modified date, but it
modified. That's what it is,
it's not going to change the date, but it could change the orientation. Like there are some things that you can change, which is why it's so important to plug it in first instead of just opening it up and opening different apps and then taking pictures of it before you ever take a full image of it, how it was in the condition that you got it in. They changed some things. And so I'm not saying it is that, I'm saying it could be that, but until we even see that, it's just endless debate because it's hard to know, because it is possible that Bunner could have done it same way he did a lot of dumb shit. But
here's the thing: is all three of the ones that they brought up at trial are all actual exhibits. Why aren't all?
There's two. There's only two.
Thank you. That's the bottom line. There's absolutely no excuse, no reason why these
Right.
should be withheld. Absolutely no
there's a
reason
ton of
why these
stuff
should be
that's
withheld. And
withheld.
that's the simple answer. Just show
Yeah.
everybody. Because maybe, maybe I'm not remembering right. Maybe I didn't have a good view. Maybe I didn't have the right
Right.
seat. Maybe I just didn't catch it. Things can happen. I totally buy it. But if we can just see what was shown to the jury, that would answer a lot of questions.
Right.
Right.
Well, that would be
Unless,
too easy.
unless what you
This was
presented
never
to
shown to the jury.
Here's the problem. If what you presented to the jury as the original video from the extraction in February of 2017 is
Wasn't?
not, in fact, the extraction from February 2017, so then it becomes an issue. But also then I'd have to ask myself, why did no one at the defense table jump up and say, that's not the original video, this is the original video, and then argue it? Could it have been that they weren't paying very much attention? Maybe. Or they just trusted that when Nick said that he was showing the
That's the
original
thing.
video that he was,
Baldwin-
maybe.
Did they
Baldwin
stipulate?
says things like that he has like this ultimate faith in that attorneys just do the right thing. He's never in his
Lord.
30 years of experience come across attorneys that don't just do the right thing.
Mhm.
So this was floored him because he just didn't understand that this was even a possibility.
Yeah.
Also, I love how like basically none of the experts were like experts. They were like cops.
Yeah.
Like all these experts were cops. They're cops
God.
that like
Mhm.
that mess around with
And
can
skilled
bugs.
witnesses.
Forget the experts. Don't get me started on the learned witnesses. What the actual fuck, Indiana? You are going to let some high school dropout DOC guard come in and testify about malingering?
Yeah.
For real.
They did.
Yeah,
they
they are.
absolutely did. It was, I have a hard time with that because they all testified on the same day. That one is hard to get through every time because the stuff they are saying it's just infuriating. It's just like it's
In
it's
addition to a lot
horrible,
of
but
those
they're also
guards that
just
testified don't even work there anymore. They've been fired.
Yep.
Some have been arrested. It's like, really? These are the
Oh, I didn't
people
know any
that-
of them had been arrested. That does not surprise me.
Oh yeah, I pulled that. I don't remember if it was meth or it was
Oh
marijuana.
Lord.
I will actually figure out which one it is. But yeah, I want to say that it was meth because I remember sending multiple people the article and I was like,
Yeah, the guards got to testify, and then apparently Harshman is an expert in all kinds of stuff because that's how he knows Richard Allen was it because he watched a bunch of videotape. Okay, well then put Max on there because Max watched all of the video footage. Let's let him testify to something. Like but they didn't. That's
I could have had so much more Max. I would have loved more Max all the time. He was freaking awesome.
I heard he was such a badass. That's part of the reason. Like, I just really wish we could have seen this. Like, I don't.
Yeah.
It's so telling to me. And like, we can read them, we can put them into AI and clone, Baldwin's voice, and it's just never going to be the same. And not just the way that they speak, but also like people's mannerisms and how they walked around the court or didn't walk around the court and just stood there like a lump on a log, or the reaction of Max when he was saying about, you didn't want me to put this in, things like that. I really think that it would have been really compelling to me, but at the same time, I'm already furious and like full of righteous indignation when it comes to this, that I think it would make it much worse. I'm finding it difficult to move on to different cases because and I've said this before, I'm like not okay with this. You were talking about this standard. What was the standard you were saying that was like, shocks the conscience? Like, does it shock? Yeah. And I'm sitting here thinking like, I think if I were to be telling the story to the appeals court, I would be basically saying, we're saying that it's okay to pluck people off the earth, throw them in prison, in solitary confinement, drug them, probably starve them, not
punish them. Also, he was punished before he was even tried.
Right. Not even just like put that. And again, someone with no history of violence or any criminal charges. Okay. And we can throw you in there and forget about you until you admit to something, and then we can use that against you. And it doesn't matter if you were saying it because you wanted better conditions. It doesn't matter if you were saying it because you were temporarily or even permanently psychotic. That's what we're going to do. And then we're going to have them.
And they're also saying we don't have to solve crimes. We can just take these
Right.
criminal defendants' word for it. We let criminal defendants solve crimes for us. When we can't do it, we're going to let these people do it. And a lot of times they are. In this case, this man has no history. But like, let's say he was one of the other suspects who had a long criminal history. Would they have done the same thing? We're just going to let all of these people with very criminal path, like very violent paths, they solve the crimes for us now. Like victims, they can just rely on the word of their killers now. Like even on that level, it bothers me.
I think it sets like I hate to use the word precedent, but I just feel like it sets an example that this is the way that we can treat people, and it'll be okay, because as long as, you know, in the end, Jerry Holman got what he went into that interview room to get. And he knew that when he went in there, that it was important that they get a confession. And when he didn't get it, he became furious and he arrested him without asking anybody else if it was okay.
Right.
And then they had to scramble for days to come up with a probable cause affidavit. And I always said, and now we know because we saw or we read Liggett's deposition.
Yep.
I always said when that Frank's memo came out, and it went on and on about how Liggett did this, Liggett did that. He changed this witness testimony. He created certain things that witnesses saw that they never saw. And they didn't, you know, never mind the fact that they didn't tell the judge certain things. Apart from that, there were, they flipped the facts to make it fit or make it less exculpatory, or, you know.
They reverse engineered everything they needed to and cherry picked it.
I always thought, I know, and I think Bob was always with me. I'm like, I know that Dick McLetus wrote that probable cause affidavit.
I thought Holman did.
It was not Liggett who changed the witness from, you know, muddy to muddy and bloody. It was Nick, because they had arrested someone for the murder of 2 young girls that the entire community had wanted to, you know, pitchfork and whatever, you know, the fire sticks or whatever, for years. And they knew that if he got out, he was gone. And I would be too. Like if you
Nick
got
is
out,
trying to say he wrote it beforehand though. In that HTC interview, he told them, oh yeah, we weren't really sure if we were going to arrest him. So we actually had something prepared beforehand. I'm like, how are you saying that? All it was a copy pasta of the search warrant with and they just introduced the gun stuff. That was the only difference.
No, Holman arrested him and they were like,
what do we do?
Now we got to write a good PCA because dummy over here, nom decided to just arrest somebody because he was mad. And now we got to be able to make it compelling enough that a judge is going to keep him in here. Right.
Right.
So
well, like, Diener would have signed anything they put in front of him.
Yeah, you better hope that you got the right guy here, because if you make me look like an ass,
I don't think Diener would have cared. He would have signed anything they submitted to him. I really do think that. But I do think for the public, I think for Nick, most of it was, what are we going to present to the public? And he knew at some point it would become public. I think that's why he wrote it the way he did. I don't think Diener would have challenged him on anything.
My bigger thing for that is that I think that is the motive for kicking the defense team off. I think that's why everything went downhill after that Frank's memo, because I believe that Nick freaked out because every accusation made against Liggett was actually
him.
And
he didn't want Liggett. Kind of like when Liggett and Goal were put in that position against each other, like which one of you is lying. Nick was like, oh shit, you know, like it's just, I think there's a lot of them who put each other in uncomfortable positions because they never expected it to go to trial, and they never expected that the interest would be continued and that people would have more like everything they tried to do to explain things away, even with the conviction itself, everything about it raises more questions than it has ever answered. And the harder they try to make it fit, the more questions we have, and the more nonsensical the whole thing becomes. Like to me, it makes sense that this man would have been a witness, but like when you try to start making him a suspect, even let alone the actual killer, it's beyond parody. Their entire case, it gets more and more ridiculous, and they have to keep being very careful. Like they had to curate this thing so carefully. And I still can't believe Nick had the audacity where he's like, and we go and search his house and surprise, surprise, what do we find? The Bridge Guy starter pack or whatever it was.
Whatever it was. Yeah.
And they knew that he didn't even have that
that.
jacket back then.
Oh.
Andrea's holding it down all by herself and she's not even
No,
here.
I had to maximize it because I wanted to see what it said. Wait, is this
Sounds
from
like
that
an idiot.
movie? Is this from Birdcage?
I think so.
Oh my
I
God.
think so. The Robin Williams movie.
You know I don't like birds, right? so my best friend.
I did not know that. Why would I know that?
Ruthie's birthday's coming up, and then we've got Christmas, and so we're just gonna send her a whole bunch of bird videos.
Well, I guess
So anybody who
like
has
birds.
instant messenger with Sleuthie, you just send her a bunch of bird videos on her birthday and on
That's
Christmas.
so funny.
Why do you want to traumatize me?
I
want
don't
you to
like
know
birds,
enough.
but I don't like
I want to see
dislike
my
them.
I've been through enough. So obviously All Eyes wasn't here, and I won't rehash the story, but you weren't here, I guess, last year? Was it last year? For the story about the bird making a nest in my wreath on my front door and then coming into my home?
No, I was not here for that. That's so funny.
She was
Personally offended.
She was very offended by this.
That's so funny.
And then my mother, Teresa, put out the screenshots of my mother. My mother's reaction
This is when I fell in love with Mom.
Oh my gosh.
to needing my inhaler and hoping that the neighbors didn't call the police because I ran out of my house screaming Bloody Mary. I left my child in here. It was banging against all the walls. It was
The birds could
biggest
have
bird.
him at that point.
He was on his own.
What kind of wreath can you have where a bird can build a nest in it?
I had like a boxwood, and my mom was like, "How the fuck did you not know that a bird was building a nest on your door?" Like
They have to come and go 100 times. No,
well,
she didn't
I
know.
saw them come
She
and
just
go.
opens the door and the bird comes in like straight at her.
It did. My kid, he wanted his blanket. He left it in the car. So at like 11 o'clock at night, I went out to go get it.
Oh my
And as
God.
soon as I opened the door, I thought it was an intruder. It was, but I thought it was like a human killer. I opened the door and it immediately flew.
What did your mom say? What did your mom say in the message?
Oh my God.
Oh, I don't know. I got a new phone. She was like,
Okay,
she was like, what? She was like,
I'm gonna find it.
yeah, I sent you.
When Andrea gets back, we have a question for her, and then we'll go back to reading our questions from chat and the.
Oh my gosh, it's so
So
funny.
anyway, to make matters worse, it left eggs in the nest in the wreath. Okay.
Oh my gosh.
Birds are terrifying, Bob. Bob never got to hear the story. I told him 10 times to go watch us tell the story, and he never did. And it's now a year later. So now he's got to hear it.
Oh, I'm trying to find the message from Mom.
I still don't understand how you can have a wreath that can support a whole bird's nest with eggs.
It was like a boxwood wreath. It was like a boxwood wreath, and it had like the
Oh my
the
gosh.
frame of it was not like like some of them are like metal or wire.
Yeah.
It was like sticks. And
Oh,
so
okay.
this bird took it upon itself to use the sticks from my wreath
Oh my
and
God.
the boxwood flowers and then mud from wherever. I had to scrub my door. And it literally when I pulled the wreath off, I was so upset. It took me a while to get a new wreath. I was mostly upset because it ruined my wreath and I had it for years. Also the audacity to come inside my house in the middle of the night. Okay, we found them. Okay, those are the eggs. Okay, and despite its bastard mother coming into my house uninvited, I still tried to care for these baby bird eggs. I don't know, Teresa, what, for 2 months?
Oh my
Yeah,
God.
they were
I don't know
dead.
how I missed all of that, but I missed it. That's hilarious.
Go ahead, show what my mother said.
I'm trying to find that one right now. Hold on, I haven't found it. I'm gonna tell him.
I love that she called the bird an intruder.
It was an intruder. Listen, I have never so fast in my life.
Oh my gosh.
It was like I pulled a trigger and like shot a bullet. Like as soon as the door cracked open,
Oh, she was waiting
this
for you.
bird flew into my house. It did not care about my face. It didn't care about my hair. And then it started running into the walls and it's going all around my living room.
Oh my
And I
God.
am screaming bloody murder, bloody
Oh my gosh,
murder.
isn't that what happened in the staircase case where like
It was the
the
owl.
lady was like doing stuff with her
100%.
Christmas decorations and like a bird got her?
100%. The owl pig theory is 100%. Listen, if I was on that jury, I'd be like, say less. You mean a bird? She confronted a bird in the hallway and then
Like,
fell down the steps?
done.
That could have been me.
Yeah.
Oh, I
That's what
believe
it
it.
sounds like.
I almost had an asthma attack. I had to get my inhaler.
That's so funny.
I told my kid, I was like, never. And then I went upstairs. He was asleep. By the time I got upstairs, he was asleep. I went outside to get his blanket that he needed to go to sleep.
He didn't even need it.
Didn't even need it. I like threw it at him. He's in his bed. I like tossed it at him and I slammed the door shut. And I thought, you know what? I almost died and he doesn't know. She said something about like, what was Ryan doing? Like, we have to figure out.
I don't remember, but it was fucking hilarious. And I wish I had it, but I can't find it. I don't know.
Now I will
What
find
was.
it.
But it was hilarious. It made me fall in love with your mom. So, okay. So in chat, they were asking, Andrea, have you had a chance to look at like the last doc drop of like 1,200 pages that just came out like 2 weeks ago? Have you looked through any of that yet? Okay. So in one of the depositions, with Trooper Roland Purdy, Baldwin tells him that they want to make sure that he's the only Roland Purdy. And he's like, yeah, I think I'm the only Trooper Roland Purdy. And they're like, well, because we had an issue this morning and they deposed the wrong Jay Harper.
Yeah.
So Jay Harper from Indiana State Police, who was part of the main unified command for all the years, the defense attorneys brought in the wrong Jay Harper and deposed him. And then told Roland Purdy about it, and then never deposed the correct Jay Harper from Unified.
Correct Jay Harper.
So somebody in chat was wanting to know if you actually had heard that.
No, I hadn't heard that.
Roland Purdy is
I had not
actually
heard
Facebook
that.
friends with Brad Holder.
yeah.
As well. We did find that out too.
I still
Yikes.
I mean, even if you wanted to follow someone if you're investigating them and you're wanting to like look at their stuff, that's one thing, but that's not how he presented it. And the fact that he didn't even feel the need to like preface it or say anything was even weirder to me.
It was weird. Okay, so let me hit up some of these questions that are in here, and then we can go back to the ones that are listed. Okay, I think I brought this one up earlier, but I don't think we ever actually got to it. So there was some orange substance in the breech face area that appeared to be from firing a certain type of ammunition.
Yes, I have a theory about this.
Okay. It's a two-parter, so if you want me to,
theory too.
you can interchange the firing pin for a P226, which is color-coded to fire 3 different caliber rounds. An orange pin is 9mm. Do we know if Rick's gun was purchased for 40 caliber or 9mm round?
I think Finn got the report for it because he got the serial number, but I don't think it's in the record.
Yeah, I don't think we know. I don't think we ever had any indication that like it was modified in any way or anything like that. My guess about the orange residue is he was firing frangible bullets. Frangible bullets are made of like compressed powdered metal, and the whole point is that you can shoot them. They're like good for target shooting because they disintegrate on impact, and so you have a much lower chance of like a ricochet or a pass through or something like that. So it's fairly common to do in a target shooting type of scenario. So that's what I had kind of assumed it was. It was frangible ammo is what she was referring to.
Okay, I forgot about that.
But we don't know because there was no follow up.
Right. I just put another one in private chat. I don't know if you saw Carrie's last one. It's kind of a good question because I forgot. Don't they have to approve?
Why wouldn't Nick have told them it was the wrong guy, like out of decency?
Because don't they have to make them requests of like who we want to depose? You have to submit it. Like, wouldn't they have caught it then that it was that they called the wrong guy?
Yeah,
I didn't even think about that.
Well, maybe Nick's just like let these idiots do whatever they're gonna do. They want to depose people. I guess they're gonna pull them in. I don't.
Wouldn't he have known? Okay, they wrote this one, but they probably obviously meant the one who worked the case, not somebody else. Like, wouldn't it have been on the state or even the judge? Who does Who does decide that?
Teresa, I just went out of my way to pull that up in Messenger.
Okay, I'll tell him. I'll tell him what it is. Hold on. Okay, here it is. Wait, why is it not telling me?
You have to click it.
I can't. You're gonna have to read it. You're gonna have to read it. He's showing me pictures of Ryan.
Yeah, she said he would have also been served the deposition notice. Yeah, does he not have a responsibility to do that? Like if he realizes, oh, this is a mistake, they have the wrong one. I guess it would be out of decency that he says something, but is there not a burden of some sort or like an obligation to be like, oh, hey, you requested the wrong one. Can you send a
No,
new
because
one?
he's going to say, "Hey, I don't run the defense investigation. It's not. I don't know who they want to talk to or why. I'm not here to second guess them or whatever."
That's such
It's
a
all
dick move,
rife
though.
with deniability. And chances are, when you serve law enforcement, you don't serve them personally. You take it to the office, wherever the office is, and so. If they direct it to whoever they want to direct with, they got to have a fun little waste your time kind of
Who is the
laugh.
other Jay Harper? Where's the second one?
I have no idea. We only
That's
figured that out
crazy.
because
I bet you.
Baldwin telling
I bet-
Purdy about it.
I bet you it was the Jay Harper, and he was like, "Oh, you got the wrong Jay Harper."
No, I'm not Jay Harper. I'm the other Jay Harper.
Yeah.
Oh my God.
Okay, hold on. So
I mean,
she
what
said-
normally would happen, like just in a normal environment, like say, okay, I've got my subpoena for Jay Harper. I take it down to the Idaho State Police main administrative office. I go up to the desk and I hand it to the lady, and they say thank you very much, and I go about my day. And they realize we don't know which Jay Harper it's for, so they would call you and ask, which person did you intend, for this subpoena to be directed to? They wouldn't just take it upon themselves to guess and guess wrong. But this is clearly an environment where the professional courtesies are not a thing. That's not part of how they operate.
Well, I think that if you do have a chance to read through those depositions, you can see the animosity or feel the animosity. Specifically from Nick to Rosie and Baldwin. And they're very professional, and they're like, so like Rosie's wrapping up one of the depositions and Nick's like, hello, like I have questions. Mm-hmm. And Rosie's like, well, we've been doing this all day and you haven't questioned anybody. Like, I apologize. Like, what do you want me to do? And he's like, well, I have questions for this one. And then one of the other ones, Nick's like, Baldwin says something like, well, I don't know. I haven't done that in 30 years. And Nick's like, well, good for you.
Oh my God.
What?
Yeah. Not
You're
surprising.
sitting there quiet the whole time. If you have something to say, it's a deposition. Say something.
Yeah. Yeah. No, I've read a couple of them. I just have got nowhere near through the whole bulk of everything. The one I specifically wanted to see was Kevin Murphy's, because for me, Kevin Murphy has been this kind of like black hole in the case. I've heard so much about him, and he seems to be like very important in the background. But he's another one that just kind of, he retired, and so now, now what? He's just kind of vanished, and yeah.
Well, he's up in, what was it, like Bayshore or what was it?
Yeah, something like that. He's up on a lake.
Oh, yeah. I thought you meant Beverly Shores, like the place he's from.
Yeah. That's where he's at now. Okay, so here's another question from chat. So after the Liggett slip of no DNA match to the mysterious sample found in the system, does that include DNA from juvenile offenders, or are they protected? So
including the system that is being referred to, assuming that that's CODIS, that will contain juveniles. It will. Pretty much any suspect, evidence is going to go into CODIS. Now, state by state, as far as like when you put somebody's DNA into the system based on like a criminal conviction or juvenile adjudication, whatever you call it, for the juvenile process where you are, that's going to vary. Some of them will put it in and some will not, but there's no like juveniles are excluded from CODIS rule or anything like that.
Right. So it's typically like in some states, it's if you're not convicted yet of the felony, then your DNA is not in there anyway, regardless whether you're juvenile or an adult. And then in other states, it's once you're arrested for the felony, then
Yeah.
your DNA is immediately put into CODIS, regardless
Exactly.
whether you're a juvenile or an adult.
I have a question
Exactly.
about that same day when they're bringing up in trial. I still am not clear. When they said that one of the DNA samples came back to somebody who worked for ISP,
Mhm.
was that person like the person later worked for ISP, or like at the time he just didn't register his own sample? Like, what was the? I feel like that's still not clear what actually happened. Like, was it somebody that was the CSI?
I
And
thought it was a lab. I thought they had clarified it was somebody who worked at the lab, but I'm not 100%
and they just
sure
didn't
about
have
that.
his on file until that happened,
I think
or
so.
okay, was it a trooper CSI? Like, because
I'm not
Olehi, he's
sure.
also a trooper, but he's not just. But like some of the people who work for the state are just like Melissa Oberg. She's not an actual trooper, but she does work for ISP because she's in the lab.
They said,
Like
yeah,
that's what
they
I couldn't
said
tell if it was a difference
ISP.
between one of the CSIs and that was on in the crime scene, like collecting the evidence. Was it one of theirs or was it an actual lab technician?
Yeah, they kept that all real hush hush because privacy. They didn't want us to know who it was.
Well, I
So
mean, even if we don't have their name, it would be helpful to know if it was a technician or one of the
yeah,
CSIs who collected it at the scene. They didn't
yeah.
even really. I tried to figure it out in the transcripts, but I couldn't. That's very annoying.
Mhm.
Yeah, in my notes from watching everybody who was in trial, it just says like matched unknown male to lab tech or CSI LE after making the match removed from CODIS.
I remember watching Lana's live that day when she was talking about it 'cause she was like, it had a, it was attached to her root, and like she was talking about a lot of it. But
The way that I understood it, it was like Olehi or Dutzman, however you say his name,
that's me.
Datsman, and then there's the other guy. There was
Page.
3 of them. Yeah, I felt like it was one of those 3, especially with the questions they were being asked on the stand. Was like, did you touch their hands? Did you touch their clothes? Did you touch anything? Were you wearing gloves? Da 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 da.
And so is the issue they are supposed to have their DNA on file for when that happens, or they don't actually have that rule, and that's why it took them so long to figure it out who it was. Because how
You're
did they
gonna have
eventually figure it out?
you're gonna have to check me, but I think the situation was that they didn't have that rule at the time. They
Okay.
did check him and then discovered it, and then subsequently, because of that, they adopted the rule that now they have everybody's DNA on
Okay.
file.
That's interesting. So like, you think like the rule comes into play, they test all their lab people or all their ISP, and then all of a sudden it pops that this is a match in CODIS, and they're just like, oopsie.
They don't put those in CODIS. Those are internal, and so typically the way that they do it is they will just sample everybody that works on the lab, everybody on the crime scene investigation and so forth, and they'll have those profiles in house. So if they get a sample and now maybe because they don't, I got to think about how this works. So they don't put it in CODIS, but maybe they have their own database that they keep it in, that they run it against as just like a check to make sure it doesn't match with that if they don't get a match from CODIS or something
Yeah.
like that. But no,
Sure,
they very
how did they
specifically
figure it
don't
out?
put those. They
Yeah,
don't put those into CODIS because they're not crime scene samples. They're not associated with a potential suspect. So if they have them in a database, it's going to be a separate database.
I want to know what prompted them to even be like, huh, I wonder, because
Right.
if there wasn't a rule, then what made them think we should check our guys?
That's
Well,
what
I
I
mean,
was
I do
wondering.
think it's fairly normal to check for contamination if you have an unexpected result.
Yeah.
But yeah, what like
But I
I
thought that
don't know what's going to
it said it
trigger
was
them to think like
mixed.
they can usually tell from the profile like, oh, if this is a trace element from the mix or something like that. Ways that they can kind of suggest that are more suggestive of contamination
Okay.
than like
So
a
they
true
can tell
picture
that or distinguish,
of
I
something.
guess.
Well, I'd say certainly not their private areas.
Yeah.
Yeah, that one bothers me because
Yeah.
that is the other thing that I can't tell if I'm like filling in the blanks out of like sometimes if I say I think something, what it really is I'm worried that this is what happened less than actually think it. But I mean, if they cross the creek, they're saying that this DNA potentially survived the laundry, but It also survived the creek and the elements, even though they were, they're saying out of one side of their mouth. Well, there wasn't very much DNA because of the elements, but then it also survived because of the laundry. But Libby, they're saying that she was ordered to undress at one side of the creek, and then Brad Weber drove by and scared him, and so then they had to go across the creek, which I think means she would have been unclothed crossing the creek. But like at one point, their bodies were washed. So how is there still any? I guess it would be a remnant, but does that have any effect on it? Like, how could it survive the laundry but not the elements? I guess, or how
On
does
your
it get?
body, though, we're talking about.
Yeah, but like on Libby, she didn't have any clothes on, and if she had been, I know she wasn't fully washed, but like if she had crossed the creek, that would have eliminated a lot of it. So how did it survive that, especially if she's not clothed? Like I don't understand it.
Also, while we're talking about this, Andrea, I don't know if you even have an answer to this, but
Mhm.
when you were listening to the testimony about the male DNA,
Yes.
was it clear to you whether it's, each male DNA in each location that they found was the same male DNA, or if
They don't know. So they don't test unknown samples against unknown samples. They don't compare them. They will only test unknown samples against known samples. And so only if they had gotten a match for multiples of the samples at the scene would they have been able to conclude that those samples came from the same person.
Mhm. Do you see that? Michael said, Andrea, if you remember, did Abby's Converse sneakers look at all muddy/dirty? In one of the leaked crime scene photos, the trim looks lily white.
Yeah, I don't recall them looking particularly muddy. I don't recall that at all. Like none of the clothing, I don't recall looking like particularly
Which I don't
dirty,
understand.
muddy.
Yeah, if you cross a creek, you're going to get wet, and then if you're climbing up a 6-foot embankment,
The
it's gonna
embankment
be
is the one that's
muddy.
really, really hard to explain. Like your knees are going to be muddy. Yeah, your
Yep.
feet and your shoes are going to be muddy. Your hands and your forearms
Your
are going to be muddy.
fingernails, like Abby's
Yeah,
fingernails, would have been caked in mud.
yeah.
And listen, I could tell you, just washing their nails isn't going to get rid of like all the mud.
Yeah,
Like
that's why I said
No.
caked in there. Like
at
it's
least
going to be in
once a
there if
week,
you're
I got to get under my
clawing.
kids with a toothpick. Like,
Yeah.
I mean, to get the dirt out of his fingertips.
Or they have to soak long enough. Like when my youngest is in bed, like sometimes she'll soak. Like if she comes in from outside, like you don't have to scrub them as long as they soak long enough. Then they can just like wash regular, and then it'll eventually come out. But if it's like freshly caked in there, you can't do that in 18 minutes.
Well, there's kind of an elephant in the room with the crime scene for me that I got some serious concerns about how it was handled, and it's the combination of we've got all this male DNA on the girls, on the clothes, in places it shouldn't be, including the underwear. But then we also have these presumptive positive tests for semen,
Yeah.
Mhm.
and these are
Inside.
not. Yes, inside from the cervical swab.
Yes.
And so these are these are not foolproof tests. Like these have an error rate certainly. But like the probability of getting a false positive on both of them seems quite low. And then when you combine that with the presence of this other
Where it
male
is.
DNA, that we're happy to just explain that away as meaning nothing because it doesn't fit our theory of the case. But circumstantially, it raises some very significant questions for me. And so I don't know how in this day and age, that their explanation at trial is, well, these are degraded samples. They were insufficient for comparison. There's not enough information available. You can do whole genome sequencing now, and it's kind of specifically for that.
Mhm.
I don't know if any of you guys are following the Long Island serial killer case at all.
Oh, yes.
Yeah,
Yes.
so that one involved the use of this whole genome sequencing. It's a fairly novel technique, so they litigated whether it was going to be admissible or not. But that's particularly like
Right.
what it's good for is being able to extract a lot more usable information out of like small quantities of DNA for identification purposes. And so to me, if you're not pursuing that with this male DNA that you recovered from the clothing, particularly from the underwear, I think it's just clear that you don't actually want an answer to that question.
Yep.
Especially after a certain amount of time passed. So, year 1, year 2, year 3. I don't care if you're still getting tips. I don't care about that. At some point, did nobody say, we have this male DNA? If we figure out whose male DNA this is on, and like I said, like with Libby, it's her bare skin. It's not all over that we know of, because they obviously didn't swab her entire body. But like,
they swabbed a lot, and there's a lot of DNA on her.
Yeah, and you'd think, like, whose else would that be?
Especially if there's someone, Abby, after they've, like, even if it was on a sweatshirt, like, you can't. That is such a. If you're gonna put your hands on someone and take their life, you're gonna leave your DNA, and if it's all over them, like, it would get on them after they passed. Especially, I can't.
I have a problem with saying that it's from the laundry, from the male household members.
I do too.
have a problem with that in terms of, like, sexual assault victims. You know, what do you do if you have a child in a house and there's an accusation like that, and a test is done and it comes back positive, and then
the laundry.
Now you turn around, now you're saying it's from the laundry. So one of two things is true. Either you are going to let people get away with sexually assaulting people, including children, or the laundry explanation is bullshit, because I've never heard an interrogation, a trial, where they did anything but suggest that the reason that DNA would be on so-and-so's underwear or bra or whatever is that they had to have touched them. They had to have put fluids on them. Never have I ever heard them say. I don't even think I've ever heard, like,
well, they just assumed it was Cody's or Derek's too. Like, that just assumes a lot. Like, oh, it's just theirs, and if so, no big deal. Like, what if it's not theirs?
Never seen a prosecution where they were so eager to explain away the presence of so much DNA. Like, it's unheard of. Like, for them to even acknowledge that, like, DNA is transferable is kind of, you know, it's like holy grail, because they never do that for all these reasons. They're finding a tiny little, you know, tiny little trace amount, and they're wanting to use that to establish something, you know, real significant. This one, they were bending over backwards to explain away the presence of all of this DNA, and it's just unlike anything I've ever heard. And it's the combination of that with the presumptive positives for semen that is such a problem for me, because it's highly coincidental.
I hadn't even thought about how it would be a presumptive, like, it would be an error, like you get an error on both of them. I just didn't even think about that until you just said it just now.
And this is the problem. I don't know what.
Is it that uncommon? So, like, for both of them to have that, is that significant, or at least
if it's like a roughly
enough to be like, we should check?
If it's like a roughly 10% failure rate, you know, 1 in 10, then for both of them to have a failure rate, so 1 in 100%, it's a 1 in 100 chance. It's a 1% chance that that's what happened. It's not impossible. That's a low probability.
And I don't know what trial Melanie Little was covering, but that's, like, my concern. So they said they blamed the semen in the underwear on the laundry. I'm assuming that what we mean by that is, like, that was the defense saying maybe it was from the laundry. And my thing is there's no way that the prosecution didn't come back and say that's total fucking garbage. There's no way it came from the laundry. So, and then here we have the hair on the finger. We never tested it. It doesn't matter anyway. It came from the sweatshirt. The hair on their breasts, or the DNA on their breasts and on their private areas inside them, inside their bodies, is from the laundry.
Well, when you have such a circumstantial case, like, you would think, okay, this is something we want to follow, but they keep saying, well, we don't want to use up the whole sample, because then what? I'm like, well, then you might find out some information.
Exactly.
But that was the reasoning, at least according to
we're gonna wait
Bogdanovsky.
until technology gets better, and then we're going to test.
They're not even using the technology that's available right now.
No,
what good does it do later? Like,
well, if
why
you're going to have a
now?
trial, that's I feel like it, and you don't have anything else, like, you're not ready for trial then.
Yeah.
But it's not, that's, like, not even the part that bothers me. Again, the part that bothers me is sitting there for 5 years knowing you have male DNA on these victims and not constantly harassing every single, like, DNA company, genetic, what, you know, all the genealogies. And why are you not even trying to figure
where's
out
the
whose
correspondence?
DNA?
Like, hey, can you guys do this yet? It's been a few years. I just saw this new thing. Like,
Didn't
I would
people
think they
offer
were
to help,
doing it.
like, for free before his arrest? Didn't CC Moore offer? Wasn't there more than CC Moore? There was like
All
multiple
holes
people.
too, I
According-
think.
According to a post by Becky Patty on Facebook, she said that CC Moore offered to do genetic genealogy after she had met her at CrimeCon. She brought that to the investigators, and the investigators told her they already have their own people on it and
Lord.
not to worry about it.
Oh my God.
That's from Becky Patty.
Ay.
I only brought this up because I had shared it in the chat. So if people want to see what the DNA, like
Oh, here's another question too.
what there was for DNA and what the results were according to trial, then there's the spreadsheet, and I had posted it in chat for you guys. So I just wanted to, I just brought it up so you can see it.
I just put Carrie's question in there too because I still I can't tell if I am understanding it or misunderstanding it. They
Yes.
At one point they did say there wasn't enough, and I don't know which sample it was referring to, but there was enough. There wasn't enough DNA to make or to develop a full profile, but there was enough to exclude Richard Allen. And I don't know if that had to do with the DNA on the girls or just like on the sticks or whatever else they swabbed. But did I understand that correctly? That it wasn't enough to figure out who it was, but it was enough to exclude him?
I don't recall that they ever had testimony about doing exclusions. I remember that we had a lot of conversations kind of after the fact about the DNA and the significance of it and what it meant, because that was a question. They were ambiguous about what exactly does it mean when you say it's inconclusive or it's insufficient for comparison purposes. Like, does that just mean you can't identify somebody? It's not enough for that. But that doesn't preclude you necessarily from being able to exclude people. So I know we were having a lot of conversations about that around that time, but I don't think they actually discussed it in the trial.
I have to look because the way I understood it,
There was a lot of reports suggesting it, but I don't know if they actually said it.
yeah, it was like that they did say that it was excluded, but so I don't know DNA like that well. So I was like, okay, so if you can't make a full profile, how can you exclude somebody? And somebody actually made me, and I can look for it. Someone made me a chart, someone that understands DNA, and I do not, made me like a chart showing how that's possible. And so let's say they could only come up with like a partial thing or even a little bit. If they have Richard Allen's full profile, then at some point, his full profile should match up with, what they do have of this sample. And if it doesn't match anywhere, then that would be that they'd exclude it.
There was a couple that were done that they could not even create a profile of, that they knew it was DNA, but they couldn't actually create any profile to compare it to anybody.
Andrea needs to go before Jeff comes in here and kicks all of our asses.
Yeah, no, yeah. Let's, Andrea,
He's going to get like one of those canes and pull her off stage.
Yoink.
I know my husband brought
throwing cats at me.
dinner too, so I'm like scarfing down food over here on the side. So
Oh, I found the part in Bozanovsky's testimony. They said, "Did you find the DNA of Richard Allen on any items that were submitted to you and described by you today that you examined?" "No, I did not." "Were you able to develop a DNA profile of any male on any of these items that you examined that you've described today?" She said, "I did not develop a male profile that was suitable for comparison purposes from any of the items that I've examined and mentioned today." And that is the only clarification they gave on any of it.
Yeah.
Who asked that question?
That was Latrell asking Bozanovsky.
I would keep looking because I just can't imagine a world in which they'd say.
Let's see.
So the amplifying is just basically copying what they already have. The issue is that so when they're doing this STR comparison, they're looking at very specific points on the genome, and it's usually like there's different numbers. It started off as 9, and then went up to 17, and like sometimes now it's 21. But so it's very different. It's very specific points on the DNA that they're looking for. And so the problem is that if they have all 19, you have a very strong basis for comparison. But if you only have 1 or 2, chances are really good that a lot of different people are going to match that. And it's not going to be precise enough to give you any meaningful information. Now, the point is it could still potentially exclude people, because if you don't have, these particular alleles in your own genetic sequence, then you can be excluded from it. But amplifying it isn't going to change that. It's just going to give you multiple copies of those
same
two
thing.
alleles that are of limited utility.
Which was why I didn't have a difficult time thinking, okay, well, maybe they couldn't match it. They didn't have enough to match it to somebody, but they should have enough to be able to like see. Now Jeff's sending in the cats again.
Yeah, he is. I know. He's got no mercy.
Go get her.
Oh,
Go get her,
the heavy
kitties.
artillery here.
Go get her, get her.
All right,
You've
guys, I'm
been
going to pop
amazing,
out,
Andrea.
feed the cats, feed
Thank
myself.
you, Andrea.
for having me.
Andrea, thank you so much. It's been such a pleasure having you, and thank you for answering all the questions that we
Definitely,
could
we'll
possibly
do it
come up with
again.
for you.
Thank
What's
you,
that
husband
one?
Do
Jeff.
it again. We're going to have a brief.
Is that Lilith?
This is Lilith.
Goodbye,
I want
Lilith.
one.
Well, you can have your mommy
Bye.
back.
Yeah. I love the kitties.
I could just see Jeff like standing at the door, like,
I know. He's like, come
"Oh,
on.
yeah, oh, mommy."
Holding the dinner. Holding the dinner, and he's like, go get her. No, that was good. Okay, so
Oh my
let's see
God,
what
it's
other
been 3.5 hours. She hung in forever. It
Yeah,
is
she did.
freaking late.
Absolute trooper.
All right. So out of the questions that you guys have on both of those lists, is there anything that we need, like, that we want to like make sure we hit on before? I know that's going to get late for you guys too. It's much later for you guys than it is for me. So I just want to make sure that any of the big ones that you guys think we should hit on before we run out of time.
Not really. There's so much. If you couldn't tell, there's just so much. It's just not possible to get like all the things into one.
Yeah.
Like you just can't. There's so many things.
This one really frustrates me just on so many levels. The fact that there are this many questions, I think, is just a problem itself. But the one, I guess it's not even really about the investigation so much as the case. I am still trying to figure out if Kara is the last person to chime in on Twitter about it, about the excluded pages. The majority of them do seem to be a result of having the victims' names in there. And so Jody excluded the entire page, even if it just mentioned a victim's name. And we know from the original action, that's not like, you don't get to do that. But getting someone to correct that, Kara made it sound like it would be on the appellate side. Those lawyers would need to do it, but that seems like something they need to be doing other stuff right now, obviously. Or I guess, I don't know if they should be doing it or not. That's kind of my question is that something they should put on their plate, or is that something they'll get to eventually? Like, you know what I mean? Like they've got a brief, they've got a deadline coming. They obviously have other things that should be their priority.
Yeah, I think that definitely as of right now, whatever they're going to go with the appeal, whatever legal faux pas they have found, they have to have already like had that prepared, because now they just have to write it up and put it in.
Well, because
based
they
on,
get all the exhibits.
Yeah,
and
but
stuff,
how if they
nothing's
didn't have the full record?
well, I think
that's
they
my
were
question.
still doing it. They were still
Did they
putting it all.
get it?
They didn't have all the exhibits. So
That's the other thing. Jody
That's what
corrected
they
the
can see
record
the
with the
faux pas.
freaks. She didn't make a new supplemental volume for the motion to correct error. We already have those because they were attached to exhibits. So Jody didn't have any control over what was excluded with those because the attorneys got to attach those. But she didn't create a supplemental volume for them. That was part of the thing that she was ordered to do, and she still hasn't even done that.
Well, she's probably on vacation. All eyes.
I know, but did they get it? Like,
probably not.
I mean, I know they have it to work with because it's in the record, but for the defendant himself, like it is his court file and it should be complete. And
that is
they're going to refer to the volumes, like the clerk's record. Why are those not in there yet?
I mean, that is their responsibility. They do have to make sure that's there.
Somebody was talking about wanting close-ups of the white car, and I'm not sure if this is what we're talking about with the white car that you wanted. That was one of the questions in chat. Is if we could, I think it was Rochelle.
What is the converted timestamp? Can you look at the bottom? Whose car is that?
It's supposed to be what's her face?
It's supposed to be Kelsey's.
I'm also wondering, because now that it looks like Teresa Liebert also drove a white car, and that could have been the one we saw on the Sandifer video.
Right.
Is that Teresa Liebert's car too? Because they said they drove around and she saw the car at the CPS building. Like, how do we know that's not her car?
We don't. That's the point. They don't either.
That's my point in asking it, by the way. But
Teresa,
because didn't they let the Kelsey self-identify their own car?
Kelsey looked at this screen grab, not even the whole actual video, and was like, yep, what time is that? And they're like 1:38. She's like, yeah, that had to have been me. And they're like, okay.
Because, well, Teresa Liebert said that her and Dave drove around 1:30. Like, and we didn't get an actual time for that. She just said 1:30, kind of like somewhere around there. And
Are you talking about, wait, are they talking about the white car that's on the surveillance footage that goes down the private drive?
well, we don't
I
know,
don't know.
what
I
color
was
that
gonna-
car is, but if it is a white car, it appears that Teresa Liebert also drove a white sedan. So I'm just saying this car,
Right.
because she did say that she was driving, like both of the timestamps line up with them driving around that afternoon. Like, why else would they have driven by the CPS building if they didn't drive along this way to see it? And then after this point in time, like if you think about it, the time at 1:49 driving by Hoosier Harbor Store, by the time you drive all the way around back to the house, they might have been back home if they drove, to the Hoosier Heartland and drove around that way. That probably would have landed them back at the house right around 207, 208.
Okay, so the white car that the chat is talking about, you think it's the white car going back on Brad Weber's property?
Maybe.
Yeah, like what if the car is on Hoosier Harbor
Now
Store
that
and that
could
one
have
is the
been
same
Teresa.
car? That's what I'm saying. Like, what if it was
Yeah.
both of them and they just said this was Kelsey? Because up until that Hoosier Harbor Store timestamp, Kelsey was saying she dropped him off at 1:38, and then you've got this Apple Health data that lines up closer to that too. And I
True.
just wonder, I'm like, what if that was actually Teresa Liebert's car? I don't know what kind of white car she might have had, but what if they're similar? And on the
All I know,
'cause-
yeah, because I just pulled that off of like Google Earth of the time frame of from
Mhm.
my from I think I actually have it up. So I can
That's
kind
just the thing. I'm the type of person I would like to double check. Like until I can know for
Yeah.
sure, it's both of those things because the time frame, if she's driving by Hoosier Harbor Store at 1:49, it might take her about 10 minutes to get all the way through town and drive back around, especially since she said they were just kind of like joyriding in the afternoon,
Right.
which I also think is weird. Like, what do you mean just driving around? Who does that? Oh, we're just gonna go for a drive
the
in this
Midwest thing,
town
I'm
where it's
telling you
nothing
right
to
now,
do.
we drove around a lot in the Midwest. I don't
I
know
know,
why.
but I do
the
think that
people-
also, if that is
Nothing
what they
else to do.
did, then yeah, she could have driven by Hoosier Harbor Store at 1:49, and by the time they finally got done with their little drive around town, it would have been 207, 208. But that means that car right there might not be Kelsey's, and we might need to go back to the other, like, I just think a lot of these, because we also know that the car on Hoosier Harbor Store at 127 couldn't have been Richard Allen's, because
Here's
the
my
yellow
thing.
jacket posts, like even the things don't work up. Like, what if that's not the only car they got wrong?
My thing about that car is and there's a couple things. One is if it were relevant and Rick's, right?
Mm-hmm.
Why then they have this unidentified black car driving by the Hoosier Harbor Store, like right when they think maybe the killer could have been driving around? Why then would they leave it unidentified for 5
Right.
years?
Yep.
Okay. And never ever ask the put out 2 fucking sketches, but not ask the public if they recognize this vehicle, number 1.
Mhm.
And number 2, they said that they identified every vehicle.
Yep.
So whose vehicle is this? Because this is not Richard Allen's vehicle.
Well, there's a video that Julie Melvin posted where she, after the arrest, she was driving. She went to go record the drive from Richard Allen's home, going the back way to the trails. And like not even that far after turning right out of the neighborhood, she drives by a car that looks just like the one on Hoosier Harbor Store video. And it could be mistaken for a Ford Focus, but it does look like closer to in Yellow Jacket's post where she put the little line to show like the tire and the light don't match up. Like the one in Julie Melvin's, like there was other vehicles along that were driving along the way that would have been on Hoosier Harbor Store. But if they didn't check, the FBI affidavit, I forget his name, but we finally got the affidavit of the person who certified the Hoosier Harbor Store video and the timestamp on it. But he's supposedly the person who identified all the cars. And so I don't know if that was one of the things. Actually, I do know that was one of the first joint stipulations was the Hoosier Harbor Store video and the affidavit. So I don't know if they can challenge it, but I do think the state should have to answer for whose car did they think that was. If they identified all of them, then whose car was that until they needed it to be Richard Allen's?
Are you guys able to share that or send it to me real quick? Because I don't have
The
it.
affidavit?
No. The white car pulling into, I don't know where I have it. I'm trying to find it. I can't find it.
Oh, let me see. I probably I don't know if I saved it.
Or send it or whatever.
Was it an exhibit?
Well, because
Are you
no,
talking about the one that was Teresa Liebert's?
Uh-huh. It was oh wait. No, it wasn't in the exhibits. Okay, never mind.
Wait,
Um,
are you asking for
um,
the picture of the one
it's
that
from
might be?
yeah, the Sandifer video.
that goes in and then like a minute later comes out. Like almost immediately
Right.
turns around and comes out.
Right. So I'm wondering, because if you remember, like Teresa Liebert says in the morning, she was
They went
in
tanning in the
she was
morning.
in the pickup truck.
They were in the truck.
Mhm.
They were in the pickup truck that morning when she saw the weird guy that shouldn't have been there.
Mhm.
So I'm trying to figure out, is the pickup truck in that video? You understand what I'm saying?
Yeah.
Like, can we see enough to see whether that pickup truck is in the video as well?
I would say not in the video that's released because that time frame is not there. But yeah, I mean, it would have to because the footage was there all the time. But the
White
camera
turnaround
didn't.
car at 208 goes in really fast and comes out really slow.
Mm-hmm.
I think. Oh wait, that's not. I thought that was a picture.
I'm gonna find it, Teresa.
I have one in my timeline, like on the timeline page of mine. Like if you scroll down, it's like cropped pictures of it, and it has like I put a circle around it to just blur out the rest except for the thing. It's on the GitHub, the timeline page, because I did include it. But it's not the picture by itself. It's like you have to scroll until you get to 207. If you scroll down, there's 2 pictures of it going in and then out, but they're you might have to zoom in on the actual page, but it would be at 207, the first one.
I didn't realize scrolling was going to be like that. I should have gone the other way. Sorry.
Yeah, you can just click the little search thing or control F it if it's easier.
Okay, so it should be right here. No?
Is it not
I'm-
on there?
I'm getting it right now.
Okay.
But you,
Oh my gosh, I didn't upload the the last one. I have to probably push it. Let me see if I can fix it. I think I uploaded the wrong PDF on there. It should be on there though.
Okay.
Like the one in my folder is. Hang on, let me pull it up. Oh my gosh, I don't even think I realized that till just now.
oh Jesus,
Kelsey
Very good.
told the story about how she catfished Libby. I can find the old interview. I have it on one of my playlists that are.
Yeah, I've always heard that, but I never.
Let me see if I can find it. That'll take me more than just tonight's live, but I'll do some digging because I have all of her old videos. What she said was that her and her friends had made a fake account to mess with Libby, but it was just like, and don't quote me on exactly what she said, but she did it like a goofy little, like, it was just like for fun, like, like we were just like messing with her, like it wasn't anything serious.
That's very annoying.
So I'll have to dig for it because, like I said, I have all the family's interviews.
Yeah.
But could I tell you exactly which one it was? No.
Okay, I'm sending you the link to it's the 213. I didn't realize that I uploaded the witness timeline one, and I just DM'd the right PDF that it is. I just looked at it. It is on the 213 one, but it's still pretty, I'm blowing it up on the
Oh, you know what? Here, I've got it.
But it's so small, like where it is.
what do you got?
The white car
You have the video?
from Shibugi's channel.
I sent you the link to the video, I think, too, but on the actual still shot of it, I can barely tell what it is.
I just looked all over Hell's Half Acre to get you this video. and those screenshots of that conversation with my mother.
All right, I'll have to.
Yep.
I don't have. Do I have? I have to have this downloaded. I'm gonna have to throw it in the editor to do a little close up of it.
Here, I'll send you. Well, okay, so this one has like the regular, like full, like full frame or whatever. So you can see the timestamp.
So there, it's coming in right now. You can see it. Take a little tiny ant right there on the screen.
And then, so the one I just sent, or that is sending, has that, like, as wide as that is. And then I don't know if this one is the same as the one I have. Then it goes in closer. And then I think it goes in closer again.
Okay.
Is somebody eating ice or something?
No, that's
I'm
me
not.
tapping on my it's my keyboard,
Okay.
maybe.
So it's zoomed in. And then is it zooming in? Is there another one that's zoomed in closer? No.
No, that might be
It's coming back out. Okay, so for context, let me pull this back up real quick so you guys can see.
Problem is when you zoom in, you lose the timestamp, but it's just not possible. But you can see it clear as day.
Well, I can cut that too. Okay, so here is the map. That what we're looking at is, so just for you guys to kind of know where we're even at here, is the girls are found over here. Here's your bridge. Here's your bridge guy video. Okay, so everything over here. So you have Weber's property, you have his drive, 625, and the Lieberts live right here. So that camera angle that we're watching that video from is from this house over here. So it's facing like this way.
So it's far as shit away.
Right. So just for a little context so you can see how far we're trying to capture it and then figure out what kind of car it is. It shows the van.
It shows the van clear because it's much bigger. And
Hold on, I
also,
think that video's playing in the background now. I don't know. It skipped to that because I was still letting it play. Sorry. Say what you were gonna say.
I don't know.
Oh shit. Sorry. Okay.
No, you're
Little
fine.
tiny car. So
Are
that's why I
you
said
in,
you
like,
look at.
what, like, quality are you in? Are you in all the quality? Like, are you up high?
You down low.
I wonder if we have the one from
Yeah, let's see where that
Osbrooks.
can go. I have. That's why I said I have those downloaded. I just don't know where the hell I put them. You know how my files are.
What?
The ones, the full one that was up on Osbrook's channel. You know when he was trying to be a YouTuber.
I'm trying to see if I can find it real quick.
Well, wasn't that a different time? You're talking about
Yeah,
the
that's
van.
the Brad Rover one. I wanted to show the van so you could see how much clearer the
Oh,
van was.
that's right. Yeah, it's not in the one he uploaded. I was trying to pull that up, and it's not in there because that's from 207.
Yeah, no, it's. I wanted to just show the difference between
Yeah.
like how much clearer the van is versus this white car that you can't actually see where it ever goes, and then it turns around and starts to come back out,
Yeah.
and then you just see it again come back this way.
All right, hold on.
So here's a closer version of it. Little white car. There it goes. So does it, that's what I'm saying, does it actually go into like the Lieberts? Because they do have a white sedan that we see on Google Earth in the 2017 timeframe. But does it make sense if she's out driving that morning with her husband at 8:30 in the pickup? Do they come home and then decide to take the sedan out for a drive? You see what I mean?
Yeah.
But
Well, that's why I think we should look, because I'm like, okay, it could be hers in the afternoon, both of them, but I don't know.
Okay, so here's a weird thing, and I don't want to get too far into this rabbit hole because that's why I said we can do that on a different live. But so Dave Liebert, Teresa Liebert's husband, becomes like a main suspect right off the bat, right?
Yeah. I didn't know that until the deposition, so.
Me either. And so they have to, so that means that Dave Liebert has to be home at the time. Otherwise, they would have been easily like, okay, here he is, he left, they're gone.
Well, I don't know if they actually did verify all the cars, but that's kind of goes back to what Sleuthie was saying. I thought they identified all the cars that were driving around on all the footage they had, but apparently not. Because then why are they acting like, oh, we should go back and see if there's any cars on video around 127. You'd think they already had a list of whose car that was because they said they identified all of them. It's just, I don't know.
Okay. I think
Michael said he'd text you the link to the van video, by the way. I don't know if you saw it. He just said in chat. I do really want to know whose black car they thought it was prior to that, or if they lied when they said they identified all of them. That seems like a problem.
Did she leave us?
No, I think she's probably pulling up the thing Michael
Oh, I'm
texted
over
her.
here talking to you guys like you can hear me.
Oh, no. I thought
I
you
was totally telling you. Yeah, Michael did send me that. Let me try to pull that up really quick. And then I was telling my screen not to actually play the next video. So yeah, I'm pulling that up. Give me just a hot second so I can pull up the van. Thank you, Michael, for sending that. Okay, and then question-wise, like where did we land with the rest of the questions from
Ooh,
Carrie?
we have
Or
to get to
from-
who does his question. I forgot about that too. After this, we need to talk about Derek's timeline.
Okay. Let me pull this up, and then we'll go on to that, so that we can try to get through some more of their questions.
Can I go to bed?
No, not yet. Soon.
This is the white van, people. Same
Yeah.
camera.
Same camera, van.
I think it's like way clearer because like it's bigger. It's just
It's
a bigger
bigger.
vehicle.
Are they two separate videos?
And it's moving slower.
Or was like the 207 to 208 video we have, did they come from the same one and we just need to, whoever clipped that part of it, can they clip a new crisper
No.
version of it?
I think I understand what you're saying. And it like,
Oh, like this one's zoomed in better. Like,
Yeah,
see,
like
there's
can they
the
just
van.
go back into the full video and clip a new 207 to 208 portion?
so no, because like the clips are at, I want to say like 8-minute sections or whatever. And so they come from 2 different 8-minute clusters.
Yeah, that's what I was trying to ask. Yeah, and so the other one
Yeah.
was already cropped like that?
No, they're all, so how that starts, how the video starts. How the video starts is how they all are. Yes. And then,
Okay.
yeah. The zoom in is not the video, it's the editing of the video to zoom in. But the very beginning, the
Who
furthest
edited the video?
What?
Yeah,
Who
like, is there-
edited the video?
I don't.
I mean, like, did it
know.
come to the public already edited and made like this, or
I think
was
Amy had it is the first one to post the actual clip of it because we had talked about it leading up to. I think we heard about it for quite a while before we actually saw it. I think Amy was the first one to post it, but I don't know if that's just how it was when she received it.
It wasn't the defense, and it wasn't Amy.
Then I
Okay.
don't know.
After the defense, before Amy. But I
Okay.
don't know if I'm allowed to say. I don't.
Oh, I actually don't know. I just remember the first time I saw it, the actual clip that we got. I want to say Amy posted it on Twitter.
It's the same person that did the clips of. So the person that did the white van clips
Mhm.
Mhm.
for the motion to correct error, and it wasn't Erica.
Okay.
Got you.
I'm also putting in something in the private chat real quick in case you don't have it handy. But this
Okay.
is, we got to get to who does this question because that is the one where you were like, is there anything else? Like, this is the one thing I did want to ask about tonight.
Okay,
It's the
do it.
Tina Garrison report. I didn't know it until I was going back through trying to get descriptions of all the exhibits according to the transcripts, like the way they were described as they were admitted or offered or published. This was there's only one page that's not excluded from this. But according to the transcripts, this report was written on September 21st, 2022, which was the same day Kathy found the tip in the drawer. It's the same day. All of a sudden, this
Listen.
report is prepared. I don't know who Tina Garrison is, but in this report, the it's the only mention of Hoosier Harvestor timestamps for when David McCain arrived and left. When when Shelby and Daniel arrived, it doesn't have the when they left. But with Derek, it places him there a lot earlier, which is interesting to me because on the live that Christine did with Gritty, she was going through her notes on early witness interviews, and I keep saying Cheyenne. Shelby Hicks and Daniel Pearson both said that when they arrived, they saw a white station wagon, like Derek would have driven. So these seem to be two separate things that would have been turned over in discovery, placing Derek there earlier than he says he was there.
Are the Garrisons the one that owned the Hoosier Harvestor?
No, those are I forget their name. It's on the affidavit. I can look it up real quick. Hold on.
Okay.
Let's see. Oh, wait, I'm in the wrong folder.
I know the name. I'm just trying to place it.
Yeah, I can't.
I think Keith is right. Pennington's.
Yes.
Pennington.
Something like that. Yeah, but it's.
I know the name. I can't place the name right now.
Well, first I was thinking, like when I first, the first time I wrote the description for this, in my head I just dismissed it as Tina Rodell. I was like, oh,
yeah,
so maybe they interviewed her, but it wasn't until the other day where I was like, oh wait, that's not it at all. And then I thought, well, who is Tina Garrison, and why is this report prepared on the same day that Kathy Shank apparently found this long lost tip? Like, what else is in this report? It's the only page we have, but the time frames for Derek on this report are a problem, except for the fact that they also said that Dave McCain's Accord is tan, even though it was apparently either black or dark blue. But it does bring in a question like, okay, what was Dave McCain driving then? And if his car was dark blue, I don't know who authored this report. All I know is that it was Tina Garrison's report, and it was admitted at, I don't know if this came from the Franks exhibits or from, let me look.
Is this in the batch that just came out like 2 months ago?
Let me see. Let me click on it again because I already.
Ron Forth, yeah, live chat will still be up, and I know like Sleuthy likes to go back through live chat too. And I'll go
I
back.
do think this is I think it's one of the new ones because the other record had the volume on it. This one only has the page number. I think it was from the Franks exhibits. Let me.
So it's from the one 2 weeks ago.
I think so.
Okay, only Tina Garrison is a real estate agent, so I'm trying to figure out like why there's a report of her.
Me too. Let me see. I'm scrolling down.
Okay, so as Blair is leaving, she noted a vehicle parked in an odd manner at the old Child Protection Service building. She said that it was not odd for vehicles to park there, blah, blah, blah. We already know all this. She reviews the tip from Terry Wilson. Wilson was on his way to Delphi on 213. We know that one. That at about 210, H observed what he described as a purple PT Cruiser or small SUV type vehicle. And then on the south side of the old CPS building, Wilson said that it was backed in, as in to conceal the license plate of the vehicle. During their interviews with both Blair and Wilson, drew a diagram and had the vehicle they saw parked in the same general area and manner. Okay, then you have McWhirter, who tells ISP Tim Kendall in an interview that he remembered seeing a smaller, dark-colored car. This is the one he says it was like a smart car. Yeah. And so he works at the Hoosier Harvestor and is seen leaving work at 2:28, heading towards the CPS building. Okay. David Riley advised that he came to the trailhead from the east. I don't think this was in the last batch. I don't remember reading this 2 weeks ago.
No, actually, I'm trying to find it now. Hang on.
I think it's from the one before that. Advised that he came to the trailhead from the east. As he was passing at the cemetery, a newer silver or gray car turns out of the cemetery. We've identified that as Fred Coghill. He is on video at 2:25, going eastbound towards the cemetery, and 2:30 going westbound, leaving the cemetery. So Riley parks at the trailhead at approximately 2:30. He is The only vehicle there, Riley walks the trail across the Freedom Bridge with his dog and back to his vehicle. When he gets back, he observes vehicles parked belonging to Shelby Hicks, which is the white Impala, and Dave McCain, which is the tan Accord. Riley is on video. He doesn't see the moped.
Apparently that wasn't there until 4 because that was apparently the Maya Abbott's. She took her scooter and Evan took his like 4-wheeler or something. And then her dad met them there, apparently, after that. It's weird.
Okay.
But it was this is from the
think I'm
August
gonna-
1st motions hearing, by the way. I just found it.
I'm gonna save this for a different. I'll do a different live just on this info with the map.
Yeah, because it places Derek there at a different time, and it has just some other stuff in there that makes me wonder. But
Yeah, I'll do a
yeah.
different live on this whole thing because we'll go through maps and photos and stuff.
But it's the only other place I've seen that was from, and I would assume maybe her, because when she did that live with Gritty, she was just going over her own work notes from looking at all the reports and doing their own follow-ups. And in her notes, she said that Derek's car, like the implication of the people she was discussing in their interviews, they were talking about the cars they saw when they arrived. Well, that would have been an earlier time frame, but they say they saw a certain car that we now know is Derek German's, but they could have only seen it if it was there, and if it was there, then that changes Derek's timeline.
I have some other info on car stuff, so yeah, I think
Okay.
that'll be good in another live. But they want me just to finish reading through this, which is fine. But I just because I know Luthi wants to go to bed, and like I said, I wanted to try to get through as many questions as we possibly could tonight without it being a 9-hour live. But Dave McCain is observed arriving on video at 2:44. McCain said there was a large pickup truck parked there when he arrived. McCain also said he saw a white station wagon type car when he arrived. Okay, that doesn't make sense. The truck is Riley in his Honda Ridgeline. The car is Derek German's. No, it isn't, because he's not there yet at 2:44. That doesn't make any sense.
Well, unless he was there. That's kind of my point, is like, was he or wasn't he?
Preza McCain said that he walked to the hub or Niches Bluff, then to High Bridge, Freedom Bridge, then back to his vehicle. He was observed on video leaving at 4:11. When leaving, he observed a female sitting on the road on a motorcycle. We have identified as Maya Abbott. Okay. She was talking to a male in a blue muscle type car. We have identified this as Carl Abbott. He also observed a male wearing a bright orange shirt. The male was shouting, "Did you see my kids?" See, that's not till later. We identified this person as Derek German. Shelby Hicks and Daniel Pearson are observed arriving on video at 2:48. They parked at the trailhead as observed by McCain. Pearson said there was a white Subaru, a 4-door station wagon, and another dark-colored car. Hicks described the two vehicles as a light-colored, longer vehicle and a brown, smaller car. These vehicles would have been Riley and McCain. Pearson said that he passed an older male just past the trailhead where they had entered, which is the whole thing. That's who I think saw Bridge Guy. That's who I think that whoever Daniel Pearson saw is who killed the girls. That is my firm belief, as one of the people at least that participated in killing the girls.
Yeah.
Pearson said that he passed the older male just past the trailhead. He described someone we identified as Dave McCann. Pearson said that the man had a camera and may have took a picture of him and Shelby. Pearson said that he saw another man that did not stand out to him that had a black dog at approximately 2:54, which is David Riley. And now David Riley is completely erased. Every interview, every article regarding David Riley is gone.
Yeah.
So, okay. All right, Sleuthy, is there any other major Carrie questions that we want to get to tonight, or do you want to?
She had so many good ones.
Yeah, do you want to I know she has a ton of good ones.
I think we should do a separate thing on like third party people, because there's a lot of questions about that.
Okay.
Like Keegan, their conversations, Elvis, Holder, things like that. I think that could be like its literal own.
Probably.
Okay.
Every part of this case could probably have its own live.
Oh,
I know.
100%.
Hence why I have 150 of them.
Yeah, it's
This was not my intention when I started covering Delphi again.
well,
ever.
this is also not normal for a solved case to be able to do this many lives afterwards after trial. It should be all answerable. I can't get over how many more questions we have now than we did.
And so I'm going to figure out who Tina Garrison is because I know the name and I don't know why I know.
I can't
that
place
name,
it
but I know
either. It's driving me crazy.
Looking in my messages, but I'm gonna look at that.
And why that day?
We'll do some more on this. Yeah, why does she have a report? Is like also
On the same day Kathy found the tip.
Just the tip.
just the tip in the box. Okay, and then so we'll kind of
Somebody
do like
really needs to like interrogate Kathy Shank.
Right?
Her name, listen, Kathy acted like she did more work. Like, I really wonder how many investigator Shank turned around and cleared
Mm-hmm.
without any permission from like actual investigators. And would they even know that? Like, would they second guess? Like, let's say they go in Orion and they see that Kathy Shank puts in an entry and says,
On behalf of
per Jerry Holman, so-and-so can be cleared. Like, would Jerry Holman even go and look in there and be like,
nope.
I don't
Well,
remember.
apparently until she brings it to them. All of a sudden, even though this man was cleared, yeah, they are giving it another look, but not until this one. It's weird. It's not very consistent.
this could definitely be a few parts.
Yeah.
the way that to answer the questions. Okay. All right. I'll come back tomorrow if you guys are available. You guys come back with me. I know that Sleuthy, I don't know if you're going to be packing or if you're going to be okay to come back on. I know you have to work in the morning, so I'm going to let you go. And then All Eyes, if you are available and want to
I'll
come
be
back
around.
on.
As long as my pies and cheesecakes and all my baked goods are done, I'm good to go.
Oh, don't
Okay.
do that to me.
All right. So tonight we're going to wrap it up. We have been on for 4 hours, and I know I'm on the earlier end of this time zone, so we'll do same time tomorrow.
Okay.
And try to go through. I don't know. We'll just.
So what time is that? 7?
Yeah. So it's 4 p.m. Pacific, 5 p.m. Mountain, 6 p.m. Central, 7 p.m. Eastern, and if you are across the pond, you have to do your own math.
I
So-
might be able to do that.
Like, I'm not doing all that math. So, but thank you guys. I mean, ladies that were up here. Andrea, I know she's not here anymore. Sleuthy, All Eyes. I mean, you're
Thank y'all
talking
for doing this.
the cream of the crop of being able to figure out like what the hell we're even looking at anymore
Right.
when it comes to this case. And hopefully people who are coming into the case will get some answers or at least some direction on where things can be found or what the important things to look at are. So we'll come back tomorrow. It won't necessarily be Q&A, kind of like it was more like we'll probably just kind of finish up Q&A, maybe third party Q&A.
Yeah.
I don't know. We'll figure that out. But tomorrow, same time, same bad channel. As always, I know you guys have 1,000 other places you could spend your time, and you choose to spend your time here with us, and we love you for it. So thank you guys. Thank you, ladies. Thank you, Ms. Burkhart. Thank you, Jeff, for allowing her on. All right. So we will see you all mañana. Go enjoy the rest of your, what are we at? Tuesday. Go enjoy the rest of your
Tuesday is.
Tuesday. Say it. Say it, All Eyes.
Okay, bye. Oh, wait. Love you. Bye.
Love you. Bye.
Bye.
And the thing, Teresa.
I need one more from you. I
Oh,
didn't get
love
to
you.
hear
Bye. Love you.
Love you,
Bye.
Do you dare to fall